Good morning, everybody. You can say good morning.
Good morning.
What we'll see where the emperor is. Is there a seat on this bench, because there's a desk that you can work from? Is there space for you to sit there? The reason is, can you make some space? Are you seated there?
Yeah, I'm comfortable.
You're comfortable?
Yes.
Good.
Yes, I'm comfortable.
Very well, let's day 2. Any housekeeping anybody wants to raise? If none, we may proceed. Thank you, Mr. Venga. You're doing a tag today.
The what?
You're doing a tag with your colleague today.
That is correct. That is correct. Thank you, judges. I'm wrapping up my argument on section 12.3 and 12.4, which is the main issue for AfriForum, and I will then briefly deal with the question of where purpose in section 25.3 fits in to the equation. Mr. Lamy will then address section 19.8. I will conclude with the relief sought in paragraph 1 of the notice of motion, and then the final relief. I do not know whether the court wishes us to make any submissions on jurisdiction. That point was not taken against us, except in one sentence of the President's aids, and the President states that he is not taking jurisdiction. But if necessary, I can address you shortly on that, perhaps at the end of the hearing.
Certainly, thank you.
Thank you. I wish to go back to section 25 of the Constitution, and the distinction there between a deprivation in section 25.1 and an expropriation in section 25.2. Now, it's generally accepted that a deprivation of rights can be without compensation. And my learned friend, Mr. Du Plessis, yesterday mentioned the case of Nslabati, a case in the Land Claims Court. That was a clear case of a deprivation that was justified and not arbitrary, and in terms of a statute. But when we come to expropriation, there's a condition. Expropriation can only take place subject to compensation. There's a recent judgment that my learned friend for the second applicant will deal with in greater detail. He referred to that in his heads. It is fresh off the press, so to speak. That is the judgment of the Constitutional Court earlier this year. Supreme Court of Appeal, I'm sorry. NAD Property Income Fund versus Sandral. A number of principles, important principles, were reconfirmed by the SCA in that judgment. I'm only going to refer to 2 for purposes of concluding our argument. Paragraph 18 of that judgment confirms that the state may expropriate property, and I'm quoting now from the judgment, for a public purpose or in the public interest, and this is an important competence that the Constitution recognizes. But then the judgment continues in paragraph 18. But so too is the constitutional regime of compensation to which the state's competence to expropriate is rendered subject. Another principle that the SCA confirmed in this judgment is that section 25.3 does not give the court a discretion when it determines what is just and equitable compensation. It states that the compensation must be just and equitable, says the SCA, and that is in paragraph 16 of NAD. The circumstances in section 25.3 are matters of fact that a court, where relevant, must determine. May I refer you to the well-known case of F&B in our bundle. It's in bundle 1, page 440. You do not have to go to that. You can just make a note. In F&B, the Constitution Secondly, if the deprivation is also an expropriation, because expropriation is a form of deprivation, if it's an expropriation, does Section 25(2) of the Constitution permit such an expropriation for a public purpose or in the public interest and subject to the constitutional regime of compensation? In our heads of argument, we give the reference there, it's paragraphs 49 to 51 of the F&B case. The deprivation is arbitrary if it does not provide sufficient reason for the particular deprivation or is procedurally unfair. Importantly, as we point out in paragraphs 37 and 38 of our heads of argument relying on F&B, the Constitutional Court rejected the submission made that the constitutional concept of property is dependent on the use made of the property by the owner. F&B also states that neither the subjective interest of the owner in the thing owned nor the economic value of the right of ownership can determine the characteristic of that right. And quoting from that judgment, a speculator has no less she has subjective but sees them only as objects that will produce money or on resale. That, of course, that goes directly to one of the new factors that Section 12(3) of the Expropriation Act brings in. On those particular sub-parts of Section 12(3), my learned friend for the second applicant will go into more detail, so I'm not going to do that. It's safe to point out that this is what the Constitutional Court gives us guidance on. Now, these dicta in F&B we submit are relevant when the challenge to the constitutionality of Section 12(3) of the Act is considered. In Section 12(3), certain categories of land are targeted for expropriation at nil compensation, or at best at substantially reduced compensation. Section 25(3) of the Constitution, I've already made the point, but I want to stress it. Section 25 of the Constitution does not have this distinction. It does not have a category of no compensation. Section 25 prescribes a weighing up process of relevant circumstances to get to an equitable balance between the public interest on the one hand and the interest of those affected. Section 12(3) of the Act changes this focus. Instead, it starts at a whole category of properties that may be expropriated for nil compensation. It recalibrates almost the test in Section 25(3) of the Constitution, which is an objective weighing up of factors and facts and relevant circumstances. We submit this is another strong reason why Section 12(3) of the Expropriation Act is invalid and must be declared invalid. An expropriator or a court determining compensation will be obliged to consider, apply and distinguish those further facts that are set in Section 12(3). Because a court, particularly, but also an expropriator, an official sitting there in his office reading the Act, will have to apply Section 12(3) because it is in the Act. It says these are things that you must consider. If these circumstances apply, should you not consider making no compensation offer? Because it's in the Act, it has to be considered. And that is what the Constitutional Court also tells the court in Indumeni. Indumeni is in our bundle 2 at page 761, and I refer to paragraph 18 in particular of Indumeni. What the Constitutional Court confirmed there is that the point of departure is the language having regard to the purpose of the provision and also the background to the preparation of the document. And it is within that context Judge Mankulu, Judge Lockwood, that the background to this Act in our submission is important to take into account. Because we made the submission yesterday that the stated purpose of the politicians who were responsible eventually for this Act was that what we could not achieve by an amendment of the Constitution, we will achieve by ordinary legislation and bring in the concept of no compensation. So a court or an expropriator cannot simply decide to ignore Section 12.3 because it impermissibly in our submission changes Section 25.3 of the Constitution. And for that reason we submit it must be declared invalid. Now the question can be asked, and some of our opponents do ask that question. The fact that Section 12.3 is not prescriptive but uses the word these circumstances may be taken into account to determine whether it's just and equitable, does not save Section 12.3. In our submission it does not, because permissive statutory powers can still be unconstitutional. The word may does not make the provision neutral. Section 12.3 guides the expropriating authority and also the court, the judge who has to decide on compensation eventually, and shapes the office, shapes the negotiations, places nil compensation into the statutory framework where it has no place as a contemplated result. The other question and an argument that our learned friends raise is, does the requirement to consider all relevant consequences or circumstances in Section 12.3, which sounds similar to what Section 25.3 says of the Constitution, does that save this section from being unconstitutional? In our submission, the answer again is no. The problem is not that other circumstances are excluded. The problem is this: nil compensation is singled out for special statutory treatment. And Section 25.3 of the Constitution already requires all relevant circumstances to be taken into account. This adds an outcome-orientated signal to the expropriator and to the court. We submit this is a different and constitutionally dangerous form of open-endedness. Another relevant question, of course, within the whole context of this case is, may Parliament prescribe the court how to exercise or conduct the objective test that it has in Section 25.3 when determining compensation? We said in the opening address that we will address this question. I'll only do so briefly. We submit that it is not that Parliament may never legislate on compensation methodology. It may create procedures, it may require office, it may regulate the information that must be supplied. All of that is done in the Expropriation Act, and that is not something by ordinary legislation prescribed or privilege particular outcomes in the Act for the court in its constitutional determination of just and equitable compensation. And we submit this is exactly what Section 12.3 and 12.4 do. Other considerations include this. Firstly, Section 25.3 is the constitutional standard. This is what has to be complied with. And we've already made the point that this is now ordinary legislation that tries to put a twist or a different perspective on Section 25.3. Secondly, Section 12.3 of the Act does not merely repeat Section 25.3 of the Constitution. As my learned friend Mr. Du Plessis correctly pointed out, it does so partly in subsection 1, but it goes on and then lists some further factors where special circumstances are listed which may require no compensation. And this places a legislative thumb on the scale in favor of a particular outcome, and that is also a point that my learned friend for the second applicant will strongly make. And thirdly, Section 12.4 is even more vulnerable because it imports the same nil compensation in a labour tenant claim case where the Labour Tenant Act already prescribes that Section 25.3 of the Constitution is the test. And there it is even worse because that determination is not made by an expropriator. It is made by the court, or if an arbitrator has been appointed to take the place of the judge, by the arbitrator. We submit that this answer that we've given and the reasons why this section is unconstitutional is also an answer to the precedents and some of our other respondents' reliance on the words may and all relevant circumstances as they appear in Section 12. Can I briefly say something about Section 12.4 of the Expropriation Act? We've already submitted that suffers the same defect as Section 12.3. But there's a more fundamental problem that is not really addressed by the respondents, and that is that Section 12.4 concerns a judicial expropriation. It's not an administrative expropriation. This Act deals with administrative expropriations. Some of our learned friends argue for the respondents that this Act deals with all expropriations. It is not correct. If you look at Section 2 of this Act, that is the application of the Act, it applies to expropriations by an expropriating authority. Expropriating authority is defined in the Act, and those are mainly organs of state. The Constitution, in turn, defines what an organ of state is, and there I rely on the quote from our learned friend's heads of argument for the second applicant, where he quoted all those sections. An expropriating authority, an organ of state specifically excludes a court. So this Act does not concern any determination made by the Land Court under Section 12, under the Labour Tenant Act, as contemplated Section 12.4. So it simply has no place in this Act. For that reason, it should be declared unconstitutional because it interferes with the workings of the Land Court, and it has no place in this Act. May I say something then about the meaning of purpose within Section 25.3. The purpose of the expropriation is one of the factors that the court may take into account in determining that just and equitable balance between what is paid to the expropriatee and the public interest on the other hand. And I mention this because one of the arguments made by our opponents is that the court can say, allowed to say or argue, because this particular expropriation is for land reform. That purpose we have to take into account, and that in itself justifies, because it's such a huge national commitment, to reduce the compensation that is payable. Now, there are at least two problems with that argument. The one is that the courts have already stated that expropriating for land reform purposes is not more important than expropriating property for a hospital in a rural area where there is simply insufficient medical care. Both are expropriations to the benefit of the public. Both are necessary. If my property is chosen to build a hospital, I get full compensation. But if my property is taken to fulfill the nation's commitment to land reform, I must now face the possibility of getting no compensation or reduced compensation. It simply makes no logical sense. And the other argument, of course, which my learned friend for the second applicant will more fully deal with, and it's dealt with quite expropriation, pay the price that is to be paid by the nation. By the nation. It is the nation's obligation to advance land reform. And the public purse must pay for those expropriations, not the individual whose property is chosen, who may be a random person. It may be someone even who's already received land through a restitution process. Why should that person get less compensation?
Mr. Wenger, isn't that where there's the two sides to the sword? So it's the nation,
Yes.
but there's an historical context
Yes.
in which the nation must be placed. And that's what the legislation attempts to address the outcome.
Yes.
And that's where these things are important.
Of course.
The history of dispossession and those are many, many centuries.
Yes. No, with that we have no gripe at all. But the point is this. I purchased a property 5 years ago. I did not get that property through any dispossession of any person. Why should I, when my property is earmarked to settle an impoverished community on, receive less compensation than when that same property was expropriated for a hospital, for example? And that point was made by Judge Gildeneys in the Mshlanga-Nisweni case. He said there, I can see no logical reason why that owner should be paid less if this expropriation is for land reform purposes and or a less mundane purpose such as the building of a hospital. And that is the point that we're making. If this expropriation is for a public purpose, it is the state that pays the compensation, and the court works out with all the relevant factors what is just and equitable compensation. But now that it's for a land reform purpose, the owner of that property must accept less. And we say that is not the aim of the Act. The aim of the Act is to address and correct those historical wrongs. And the Constitution allows that to be done through expropriations. And with that we have absolutely no problem. But it is singling out those properties that have to be used and expropriated for land reform purposes, to give those owners, the unfortunate owner whose property is targeted and who may have no part in the historical dispossessions, to accept less. Of course, if there are if there are circumstances which make it relevant, this owner has obtained this property through improper means or dispossessing persons. Of course, that is a factor that the court under Section 25(3) will take into account in whatever the adjudication is. So we're not defending that, and that is not the issue before the court. But let me get to the real, what we say the real meaning of purpose is. How do we understand purpose in Section 25(3)? And I want to illustrate that by two examples, because then it's easier to illustrate what we want to say. I'm the owner of a property. That property is earmarked for the establishment of a much-needed sewage plant. This is well known that this is going to be established by government. Nobody wants to live next to a sewage plant, so the property values in that area drops. When compensation has to be established to expropriate me, to compensate me for the expropriation, the purpose of that expropriation becomes important, because if you now just do a market value valuation of my property, it's going to be very low because the property prices have dropped. So the purpose of the expropriation is then taken into account by saying we ignore that drop in the market value, and the court then determines what would be just and equitable, because that would be just and equitable towards me as the owner. But now let's take the reverse example. My property is earmarked by the authorities for the creation of a new commercial hub. It's well known. Property prices in the immediate area triple. And I'm now expropriated, or my property is expropriated, to establish that commercial hub. It would now be unjust towards the public if this increased market value is used as the baseline to compensate me. That is where the equation comes in. Then it has to be balanced out, and this increase in the property price has to be ignored. So the purpose of the expropriation is taken into account and then neutralized to get to a just and equitable weighing up. So that is what we wish to submit on the purpose, and that is.
But is that the purpose in that context?
Yes.
Is not only in respect as to whether the market goes up or market goes down. It's fundamentally the purpose for which the expropriating authority wants to use the property.
Yes.
But it's not only confined to where the index of the market.
No, and that's. I just gave an example where it affects the market value itself.
But
yes, but there the purpose is taken into account.
No, but the purpose of calculation,
yes.
It will be neutral because, as you correctly point out, if it goes down, if it goes up, it must be ignored.
Yes.
It doesn't detract from the purpose for which the property used to be expropriated.
No, that's also not the argument. The argument is that the purpose of the expropriation, namely this positive or negative thing, is taken into account in that balancing act. So if the purpose of the expropriation affects the compensation that must be paid to the owner in another way, not necessarily the market value, then the purpose is taken into account to ensure that there's a just and equitable balance.
Except that, but for the purpose of market and how it impacts adversely or positively, that is not taken into account. But the actual purpose for which the property is to be used by the expropriating authority, that's taken into account.
No, but
one is neutralized because when the determination is made, the fact that it has gone up or it has gone down, that is taken into account to the extent that the market value as at the date in which the property would have been sold on the market. Sold on the market irrespective of the expropriation. That's the value that's taken into account for the purposes of determining market value.
It's not with respect completely correct, because the value of or compensation is determined on the date that the decision is taken to expropriate. Under the old act, it was on the date of expropriation. Under the new act, it will probably be the date on which the state decides to expropriate and then makes an offer. So at that stage, in my example, the market value is much higher than and it would have been because of the purpose of this expropriation, because it's known out there that it's on the cards. And so the purpose is taken into account in the Balancing Act in that particular example.
Can we go back to the issue of purpose?
Yes.
I understand the other side's argument to be that, so assuming they want to build a hospital on the land to be expropriated, they would argue that notionally it could also be known in those circumstances on their interpretation of Section 25.
How they get to that, it's difficult.
As I understand the argument
Yes.
is that 25.3 enables a no compensation, irrespective as to whether it's for public purpose or for public interest. That's the argument.
Yes. We've already said that, well, if that in the end is what a court concludes after weighing up all the relevant circumstances, and I've already submitted yesterday, I cannot think of a case where that is even possible. Then it is the court that has conducted its factual exercise, weighed up all the circumstances and came to a conclusion. That's quite different from what is stated in 12.3. Now, I know, as an afterthought, my learned friend for the President now argues that, well, if the argument is correct that 12.3 is only aimed at expropriations in the public interest, then the court must also then read in 12.3 public purpose as well. But
they say you don't even have to get there. Some of the amicable matters. So you don't even have to get there. It's simply an interpretation to be given to 12.2 and 3
Yes.
together.
yes,
So the two must be read together. And they say on that interpretation, that could notionally even get you to know.
yes. But
That's the argument.
my answer to them is, so what? If that is what the Constitution says that is what the Constitution says, why now bring in a special category where you predetermine null compensation? And that is the argument that I've made this morning.
Predetermined. No, they say it's not predetermined. and
Yes.
it's a question of language is important.
Yes,
They say nothing is predetermined. Yes, it's clear. It says made.
yes.
All it does is to list the factors that they. The argument.
Yes.
I'm just careful that we don't
Sure.
use the incorrect language to describe what the argument might be.
I take the point. We've already given the counter arguments to that, which I do not intend to repeat. Do I have to say anything about sections 19.2 and 19.3? It is admitted that there's a drafting error, that those two sections, as they read now, are invalid. We've made out the case there, and I do not have to repeat that with
in one
respect.
sentence, remind us what your solution is.
Well, the solution is the more difficult question, and as my learned friend for the DA pointed out, there are about 9 proposals as to how it should be done. But we say the primary remedy is, well, of course, declare it unconstitutional, but then remit it to Parliament that they can do their work, because this Act is not yet in operation.
What's the trigger on your client's proposal? What will trigger the 180 days?
What my client's proposal is, I'm not too sure. My personal inclination, if it's relevant at all, was that the intention was clearly, whichever version of the Speaker one accepts, is that the words in section 19.2, notice of expropriation, was meant to read the notice of intention to expropriate. But I think, Judge Salvani, you've already pointed out yesterday in argument that there are also problems with that interpretation, because then it takes away the time that you have to try and mediate and settle. And mediation is something that really works. I've also recently done that course, and it opened my eyes as a lawyer, a litigator, to the possibilities of mediation. So it's not something that one should disregard. So for the moment, the Act is not in operation. It should be declared unconstitutional. That declaration has to go out to the Constitutional Court, where it becomes either final or not. And I can't see that on Section 19.2 the Constitutional Court will not confirm the invalidity. And then it's really up to the Constitutional Court to determine a remedy, and that is where we submit it should be done, and that's perhaps how the judgment in Prince 3 is to be read. But of course there is the possibility that the President may decide, I'm going to put the Act in operation, and then this court is entitled to provide interim relief, and that interim relief will then only kick in if the Act is put into operation before it is finally determined by the Constitutional Court. And for that, you have many options before you. Perhaps the better solution would be to say that period starts at when it's clear that negotiations have failed. That would be our suggestion in respect of that.
Negotiations or mediation.
Yes. That would give the parties sufficient time to try and mediate this. So, but the primary relief that we seek there is a remittal to Parliament. Perhaps before I was going to ask my learned friend how to deal with Section 19.8, but perhaps I should just say something about paragraph 1 of the notice of motion in the AfriForum case. I do not want to spend any time, because that does not really affect the constitutionality of Section 12.3 and 19. That prayer reads that the declaratory order that the late publication by the President of his assent to the Expropriation Act is declared unlawful and unconstitutional, and we added accordingly set aside. But the argument that we make out is that there's an obligation on the President under the Constitution to promptly publish his assent and signing of an act. In this particular case, it was signed and assented to on the 20th of December 2024. It was only published more than a month later, on the 24th of January 2025. And what grabbed our attention is the fact that it was only made known by the President, even to the minister who is affected by the Act, on the day before it was published in the Government Gazette. And the argument there is that this takes away the right of Parliament, members of Parliament, to refer this court to the Constitutional Court, as they are entitled to do, to determine the constitutionality. But the 30 days have run out by the time that the signing and assent became known. And it's the signing and assent on the 20th that triggers that 30 days. That's when it starts running, not the day on which it is published. Now, unfortunately, the President's explanation for this, he calls it a slight delay, is not satisfactory. He says that it was public holidays in December and everything was closed. But on that same date, the 20th, he signed at least 8 other acts into power, and those other acts were published within days after the 20th. Some on the 24th, some on the 27th. Government Printer's Office was not closed. There were several publications from, I think, the 3rd of January up to the 20th. So the explanation, unfortunately, does not does not satisfy.
The
So,
defendant to that supporting affidavit doesn't even take the opportunity of correcting himself for us.
yes,
I
we've,
was a bit surprised by that.
yes,
Because it was simply factually incorrect,
yes,
and he simply persisted with it.
yes. We've mentioned that in the replying affidavit.
Yes, that was not very helpful.
Yes. Well, the point we make is public officials, especially the one in the highest office, should sometimes be reminded by a court, you have to comply with the Constitution, even if it's just to make an order that what you've done is not constitutional.
Is this essentially not where that the Constitutional Court should be saying and doing,
Perhaps it is.
rather than
Yes.
three lowly placed judges?
I wouldn't say that. Judges, that concludes my argument in main. If I may now pass the baton to my learned friend. Thank you.
As the court pleases, the argument in the heads of argument pertaining to Section 19, Subsection 8 of the Expropriation Act is contained in pages 58 to 63 of the heads of argument. I do not want to repeat what is stated in the heads of argument. I intend only to focus and highlight certain aspects that flow from the argument in the heads of argument. I do want to start off with the judgment of the Constitutional Court, my apologies, a judgment of the Supreme Court of Appeal pertaining to Section 18, because Section 19.8 directly seeks to override Section 18.1 to some extent. And I will deal during the course of my argument with the entire constitutional purpose of the Superior Courts Act, and including Section 18, which Section 19.8 of the Expropriation Act seeks to effect. That the bundle 2 of our authority bundle is just behind the chair of Justice Mungo Lockwood. No, I think it's the bundle below. It's bundles 2 of 2. Bundle 2 of 2. Yes, it's bundle 2 of 2 of the AfriForum's authorities bundle.
You can see that from there.
I've checked yesterday that we can find it quickly.
Consistency is your eyesight beyond that. Thank you. Tell us what page we should be.
Yeah, this is the judgment of Ntlameza versus the Helen Suzman Foundation. Judgment of the Supreme Court of Appeal, starting on page 773 of volume 2 of 2. To paginated page 778, and particularly paragraphs 28 and 30. From paragraph 28, the primary purpose of Section 18, subsection 1, is to reiterate the common law position in relation to the ordinary effect of appeal processes. the suspension of the order being appealed, not to nullify it. It was designed to protect the rights of litigants who find themselves in the position of General Ntlameza by ensuring that in the ordinary course the orders granted against them are suspended while they are in the process of attempting, by way of appeal process, to have them overturned. The suspension contemplated in Section 18.1 would thus continue to operate in the event of a further application for leave to appeal to this court, in the event of that being successful in relation to the outcome of a decision by this court in respect of the principal order. Section 18.1 also sets the basis for when the power to depart from the default position comes into play, placing that in the hands of the court with regard to establishing exceptional circumstances on the other party to depart from that general principle. And then namely exceptional circumstances which must be read in conjunction with the further requirements in Section 18.3. As already stated, and as will become clear later, the legislature in the Superior Courts Act has set that bar fairly high, and with purpose and reason, I would submit, with regard to the proper administration of justice. Now, Section 30 also becomes important, but because here the provision in Section 18 is directly related to Section 173 of the Constitution. Section 30, paragraph 30 reads, moreover, contextually, the power granted to courts in Section 18 must be seen against the general inherent power of the courts to regulate their own processes. So what this means, I submit, is that Section 18 is designed for proper administration of justice and court processes. And that falls within the domain of the courts. Then this paragraph 30 says, the inherent jurisdiction is now enshrined in Section 173 of the Constitution, which provides the Constitutional Court, the Supreme Court of Appeal, and the High Court of South Africa each has the inherent power to protect and regulate its own processes and to develop the common law, taking into account the interest of justice. Now, if one then considers the Superior Courts Act and its purpose within the Constitution, one may only start with understanding that with reference to the preamble of the Superior Courts Act. It starts with an important point, noting that, I'm reading from the preamble of the Superior Courts Act, that Section 1 of the Constitution of the Republic of South Africa, 1996, provides not that the other branches of government, like Parliament or Executive, are not also to uphold that, but the courts are here the watchdog of the rule of law and the supremacy of the Constitution. And then it goes on by reference to Section 165 of the Constitution, by vesting the judicial authority of the public is vested in the courts. I don't want to harp further on that. And then, importantly, it refers to Section 166 of the Constitution, which provides that the courts are the Constitutional Court, the Supreme Court of Appeal, the High Court of South Africa, and then the Magistrates Court and any other court established in terms of an Act of Parliament. And this is also important, and I'll come back to that, with reference by the Constitution when it comes to the determination of just and equitable compensation where the Constitution refers to a court. Court is not defined in that with reference in the Constitution, but clearly court doesn't stop of just an equitable compensation on an issue, issue. And therefore it changes, it absolutely changes 180 degrees, Section 80, by putting the onus on the expropriatee to bring an interdict based on a higher benchmark by saying compelling reasons if you want to stop giving effect to the expropriation and what has the court has been determined as the just and equal compensation. Now, on various levels, this is problematic. It infringes the powers of the court, power with regard to the administration of justice, with regard to appeal processes. It infringes the long-established common law principle of suspending an order whilst an application for leave to appeal is pending. And we know that the benchmark for leave to appeal is reasonable prospect of success or any other compelling reason which the Superior Court Act has stipulated. But importantly, also in the preamble of the Superior Courts Act, it says, and Section 171 of the Constitution provides that all courts function in terms of national legislation, and their rules and procedures must be provided for in terms of national legislation. And then it says further in the preamble, and Section 180 of the Constitution provides that national legislation may provide for any matter concerning the administration of justice that is not dealt with in the Constitution. So the conclusion is, with regard to the interpretation here of the Constitution, as well as read with the Superior Courts Act, is that the Superior Courts Act is the national legislation envisaged by the Act to give to place the function in the administration of justice function in the hands of the court. It brings me to another aspect with regard to Section 19.8. Is that we didn't say that in our heads of argument, but I was thinking about this in the development of my oral argument. We know how the courts caution about overstepping the separation of powers when it comes to the powers of the legislature or the executive. But the same obligation is there on the legislature in terms of our constitutional separation of powers doctrine, not to overstep by way of legislation into the function of the courts. And that is what Section 19.8 does. And I want to submit further that as much as the Expropriation Act as a whole is intended, and I'm not thinking now, I'm making this submission in the context of what the argument is by the respondents with relying on Section 36 of the Constitution. This, although the Expropriation Act is a national legislation, in order, by virtue of Section 25, when it comes to expropriation of property, I submit that Section 19.8 as a provision cannot be regarded as national legislation insofar as it purports to deal with appeals to further courts and changing that position of suspension of an order and so forth. So what I'm saying is It is the national legislation in the Superior Courts Act that govern that. So the reliance on Section 36 by the respondents, because Section 36 relates to a law of general application. That law of general application is the Superior Courts Act and the national legislation when it comes to the administration of justice and the appeal processes. Then, if I may turn to Section 19.8 itself, I just want to get the Act before me. It says, appeal against the decision of a court on the amount of compensation. Despite Section 18, any appeal against the decision of a court on the amount of compensation will not prevent the expropriation authority. In other words, it becomes at the level of a decision of only the High Court on matters that could be notoriously difficult, as we already know from the case law. The NAD case, which my learned leader has referred to, and which my learned colleague, Mr. Bostrom, will also further refer to, is an exact recent example of how notorious difficult the application of the Section 25 factors are in the determination. And if one considers also what is stated in Erasmus with reference to the well-known judgment of In South Cape Corporation versus Engineering Management Services, which was a judgment delivered in the Supreme Court of Appeal by Judge of Appeal Corbett, as he then was, and where he said the purpose of the common law rule, I'm referring to Erasmus Superior Court's practice at pages D120 and D-121. The purpose of this rule as to the suspension of a judgment on the noting of the appeal is to prevent irreparable damage from being done to the intending appellant, either by the levy of a writ of execution or by the execution of the judgment. So what the state wants to do here, at the first level of the High Court decision of determination of just and equitable compensation, they want to execute. They want to proceed with the expropriation. And that is actually also defeats their own argument with regard to 19.2, because they've conceded that the expropriation cannot follow unless the court has determined just and equal compensation. But they stand with the defense on 19.8, but then only at the level of the High Court, and then placing, I would submit, an almost insurmountable onus on the expropriatee to bring an interdict in order to avoid that based on compelling reasons. Now imagine an application to the High Court to establish compelling reasons on matters of fact, in a dispute of fact and a determination based on expert evidence, and to canvass that in an application in order to convince a court that it should depart from this general provision in 19.8. I mean, one can just imagine the insurmountable difficulties an expropriatee is being faced. In the ordinary course, if you look at Section 18, the onus will be on the state if it's dissatisfied with the determination of compensation. But it can also be on expropriatee, of course, because I mean, but then that expropriatee must establish exceptional circumstances. My apology. Well, it cannot take effect unless it has been determined by a court. Now the court has determined the amount of compensation, and the expropriatee wants to appeal. So what he has to do is file an application for leave to appeal, and obviously for leave to appeal be granted, establish reasonable prospect of success. In this case, this expropriation is going to proceed after the first court has determined, the court of first instance, the amount of determination, which I said is a constitutional issue, and therefore there is a very high hurdle to exercise your right of appeal further to the Supreme Court of Appeal and to the Constitutional Court. And I submit for those reasons that this provision is directly unconstitutional, pertaining because it infringes the powers of the court, but it's also irrational.
Mr. Lemon, I can understand where low compensation has been determined by a court.
Yeah,
And that would
yes.
possibly result, possibly irreparable out when low compensation determined by a court of first instance. No doubt that will also be taken into account when the court determines compelling circumstances. I want to come back to that. 170 talks about the process of the court.
Yeah, but your appeal, Section 18 is exactly about that.
It's the process.
It is, yes. It's about the administration of justice process pertaining to appeals, yes.
And the question of suspension, is suspension of an order a process issue?
Yes. It is indeed. And that is what the common law has said. It says here, in the discussion in Erasmus exactly points to that. The origin of Section 18 is the common law. That common law is a common law rule of practice and process. It says here, Erasmus says, the purpose of this rule is, as to the suspension of a judgment on the noting of appeal, is to prevent irreparable harm. So that rule is to freeze a process of execution, to stop a further process of the execution of a judgment. It is, I suppose, process. No. That is fundamentally a constitutional issue. That is not a procedural issue. No. But it is the further process following that is affected by Section 19.8. It is the process, the general common law principle of suspending a judgment to allow you to exercise your right to a higher court in order to also, and the other rationale of that principle is to prevent irreparable damage. Now, Your Lordship, Judge Saldana, the problem become exponentially bigger when you consider Section 12.3, correct? But if you look at the judgments also pertaining, as I said, the complexity sometimes of determination of just and equitable compensation, and you can have huge and vast differences between what is now in the later legislation legislated and which the state relies upon is the valuer general and his methodology of determination of compensation. The whole issue of market value, and that is become very pronounced in the NAD case. So it's not only with respect to the danger of a null compensation determination in 12.3, it equally applies to also other determinations of just and equal compensation. And we know why. Where's the constitutional rationale for access to courts and the higher courts as much as an important issue with regard to a constitutional matter where expropriation is subject to compensation and the determination of just and equal compensation. One cannot imagine that you must have this provision on a constitutional issue, and for an expropriatee to have such a high hurdle of making for an application for an interdict on a standard of compelling reasons. I can go so far as to submit this whole test of compelling reasons is just an arbitrary thing. Yeah, if we would nowhere, even if you look at the principles of an interdict, is that an element?
Doesn't this come in when you need to balance the interest of the expropriatee together with the interest, the public interest, the purpose of the compensation?
Well,
Doesn't that create enough throughout
well,
the whole process?
well, let me take the argument of the respondents as I understand it. I think the President says so. I say the purpose here of 1908 is to prevent further delay. Now, I want us to perhaps pause there, just to demonstrate that is not, with respect, a sound argument. One of the cases that I have looked for purposes of my argument up again is a matter where I appeared in the Supreme Court of Appeal. It's a judgment delivered by Justice Harms. A full court judgment, but Justice Harms, Deputy President as he then was, delivered the judgment. And the point I want to make is how expeditiously, if you talk about delay, the most time with regard to determination of compensation will be at the High Court level, because that is where the factual disputes and the expert evidence is going to play out. Your appeal process thereafter is relatively short. And let me just illustrate with reference to this dictum by the Supreme Court of Appeal. In this case, the matter is Law Society of the Northern Provinces versus Mughami. It is reported 2010, Volume 1, SA 186, Supreme Court of Appeal. And at paragraph 3 of the judgment, in this case, there was a long delay after there was an application for leave to appeal by the attorney concerned, and the hearing of the application after the application for leave to appeal is filed, and then the hearing of the application for leave to appeal. And then there was a long delay for delivering judgment on the application for leave to appeal. And the court said the following: although the full bench was able to deliver judgment on the merits within 6 weeks, the application for leave to appeal was handled differently. The application was filed on 15 November 2001. The matter was heard on 14 March 2008. It delivered on 3 October 2008 a one-page judgment granting leave. It is inexplicable why such an uncomplicated judgment took so long to deliver, especially in a case such as this, which not only affects the parties, but where a public interest element is involved. Then the court refers to the well-known matter of New Clicks, and we all know versus Shabalala Mzimang, NO, and Pharmaceutical Society. That was a judgment of the Supreme Court of Appeal, where the appellants directly approached the Supreme Court of Appeal, where there was a delay in this court about hearing an application for leave to appeal. And then Judge Harms says, courts are obliged to deal with applications for leave to appeal expeditiously, and systems ought to be in place enabling courts to hear them soon after having been filed. There is also no reason why they cannot be disposed of in chambers without oral argument. Now, to take that further, if that is done expeditiously and in the public interest after a determination, and considering that that your processes in the Supreme Court of Appeal and the rules of the Supreme Court of Appeal also make provision for degrees of urgency in expeditious hearings of appeal, as well as the Constitutional Court. I mean, if a matter is in the public interest and in a given situation, that case can be established, while those appeals must be done with expeditiously, it can be done. The court processes allows for that. And it is within still the function of the judiciary and the courts to expedite those matters. It is not for Parliament to come under a so-called argument of a necessity to legislate it in order to prevent delay further. And as I say, you know, when the matter goes to the SCA after a High Court judgment or to a full court, the courts can arrange those matters expeditiously. But it is not for Parliament to interfere with those processes as they purport to do in Section 19.8 of this Act. Those are my submissions. My learned friend will...
Thank you, Mr. Lambert.
Thank you.
Mr. Lambert, you have
I need 30 seconds, and that
30
will take us
seconds
to tea time.
Okay.
I just want to remind you of the orders then that AfriForum in this application seeks. The first one is an order in terms of paragraph 1 of the notice of motion. Then secondly, an order that sections 12 sub 3, 12 sub 4 and 19 sub 8 of the Act be declared unconstitutional. Then that pending the amendment of section 19, that section 19.2 and 19.3 of the Act be declared unconstitutional, remitted to Parliament to amend within a period of 24 months after the date of this order. Fourthly, that pending the amendment of section 19.2 and 19.3 by the Parliament, the Court grants interim relief in terms of section 172 sub 2 sub B of the Constitution by deleting the reference to notice of expropriation in subsections 19.2 and 19.3 of the Act, and reading in the words notice of intention to expropriate, alternatively the day on which mediation terminates, and that such temporary relief only becomes applicable should the Act come into operation before the matter is dealt with either by Parliament or by the Constitutional Court. The fifth prayer is that the order of invalidity in respect of sections 12.3, 4, 19.2, 19.3 and 19.8 of the Act be referred to the Constitutional Court for confirmation. 6, that the respondents are ordered jointly and severally to pay AfriForum's cost of this application, including the cost of 2 counsel on scale C. And my learned friend, Mr. Du Plessis, has already submitted, based just on BioWatch, on section 19.2 alone, we are entitled to such costs. And then lastly, that the normal order that the registrar of this court is directed to lodge a copy of the order with the registrar of the Constitutional Court within such time as this court may deem just. We thank you for the opportunity to present our case.
Thank you, Mr. Lambert and Mr. Lambert. Ms. Kita. Yes. Thank you, we adjourn for tea.
Because I already provided for the time for consideration in the mediation. Where's the other friend?
He's got water. It's fine. More water the better. But so like this, so I'm saying that the purpose was if they put a switch next to you change those annual then you take that
as a general proposition in the calculation of compensation. We also accept that the Act very usefully adds things such as the 5.1b says that there must be consideration of the existence of unregistered and registered rights in the property. It's a sensible proposition that should be done, and it's very useful that it is. 12e says there must be consideration of the interests of a mortgagee. Obviously important because the mortgage is going to disappear once the property is expropriated. Sorry, thank you. I will. So, saying that these introductory provisions that that provide good guidance in the Act. 12.1, the interests of a mortgagee. It's very important that that's there. The mortgage is going to disappear once the property is expropriated, and obviously banks wouldn't want to be left with unsecured debts, and property owners wouldn't want to be left with a debt to a bank but no property that it was used to purchase. So it's not that we don't have that we have a problem with the existence of guidance, but what we do have a problem with is what we submit is that 12.2e and the 12.3a to D and 12.4 are qualitatively different. And we'll discuss the meaning of each of the provisions in turn, but each something. That there's a bit of delicate footwork by our learned friends for the various state respondents about what exactly these provisions are doing. Then they're not binding, they're not mandatory. Are they just examples? Must they be considered? May they be considered? We'll get to all of that in a moment. But they must be doing something. It can't be that they are mere surplusage, that the legislature has put sort of, hey, what about this? Have you considered that? Are you aware that this is a possibility that you can also look at? This is legislation. It's not an inter-office memo. It's not a guideline document or a policy document that's being distributed intra-departmentally. And what we're submitting is that as soon as we start giving these sections meaning, as soon as we start like what are they actually doing, they immediately become problematic, because what they do is they put a thumb on the scale. They put a thumb on the scale of on the side of reduced compensation to the property owner. And it's substantially reduced. And it's substantially reduced when certain factual situations, scenarios, exist. So it's not like 25.3. So 25.3 of the Constitution points to circumstances, stated neutrally. And you made factual determinations about those circumstances. Here you have specific factual situations, and the expropriating authority who is considering a particular case is told these factual situations are important. And all other things being equal, it's going to substantially reduce compensation in these cases. And we submit that the problem with that is that the delicate balance of interests that goes into the 25.3 process effectively is undermined by that. And we'll explain exactly why that is. So we would agree with the AfriForum and the Vaderlandsstichting that there is a fundamental discordance between 25.3 and the impugned provisions in the Act. We would say that it might be slightly more complicated than a one-page judgment, but it's quite a complicated issue. But we'll submit that fundamentally, and we'll show you why we think that there is this inconsistency. And to do that, the best place to start is with the NAD judgment, which was alluded to earlier this morning. It's a judgment of the SCA, the 1st of April. It is in the very bundle. Just to avoid having to scratch around for the moment, I have just made 3 copies. If you could just... And so what we do, start off when we're looking at it's paragraphs 10 and 16 that I'll be looking at, but what effectively we see is that in that judgment, Mr. Justice Unterholzer says that there is Section 25.3, he describes it as the constitutional compensation norm. It's a useful description because it does come back to the fact repeatedly that what we are dealing with here is a constitutional norm. And if we start on that basis, the approach that is adopted by the court in that case, we see that three effectively cascading principles that we can sort of extract immediately from 25.3 of the Constitution. And so the first one, the sort of headline, the lodestar that we're all following, is just and equitable. And thankfully, we weren't just left with those two words, which would have made things a lot harder, because the Constitution immediately goes on and says, what is just and equitable must reflect an equitable balance between the public interest and the interests of those affected. So that's how we've fleshed out for us, thankfully, that it's this equitable balance provision. And then the third tier of this cascading set of principles is that this balance is then based on all relevant circumstances. So we have the enumerated circumstances in 25.3a to E, and then we have, and we're told there may be others. Now, in each case, you're going to have to look at those enumerated circumstances, and you maybe determine that there are others. And the important point that the court comes to, sort of dealing with that in the NAD case, is in paragraph 16, is that what comes up is that section 25.3 is not cast as a regime of discretion. It's a constitutional norm. The aim is just and equitable relief. It's not a discretionary function. And this has all sorts of consequences, and which the judgment deals with. We mentioned just another one before that, is that it affects the type of guidelines that legislation can give. It's different to Darwood, where you've got an open-ended discretion that's given by legislation or by regulations, and there needs to be guidelines for a discretion. This isn't a discretion that an expropriating authority have. They are exercising a power that comes from the Constitution, and they're being held to a constitutional standard. So the guidelines must be wedded to that constitutional standard. You're not just guiding a normal sort of administrative discretion. And what the court tells us is that why it's not a matter of discretion is because where you start with these things is by making determinations of fact. So these neutral factors that we have in 25.3, they don't point in one direction or the other. How the property has been used, the market value, its history, none of them sort of necessarily dictate an answer of higher or lower. There are circumstances that you would look at. So you would go under them almost as headings and make factual findings. And with those factual findings, and what the court continues with is that you build it into an objective inquiry to find out what evaluations can be supported, or what conclusions the evidence supports. And at paragraph 17, the court continues that these facts and conclusions are then taken into this balancing inquiry that the Constitution takes us to. And the court highlights that of course there may be differences between one official and another, or one judge and another, about how those facts actually hang together. But what it says in paragraph 17, the court says and that it also, the court noticed very importantly, is that it engages a complexity of history, distributive justice, and a constitutionally sanctioned recompense. So we have all of those things. It's not easy. But at the same time, we're looking to say what we can get a few principles from this. So principle number one is that it's not some free-floating discretion when you're getting to an amount. And ultimately, we're getting to a number here. We've got a test, but we're getting to a number. But it's not some free-floating discretion. It's not some sort of intestinal precognition that you have or you don't have. It's a constitutional standard that you have. It's not a viable argument. You are looking at a constitutional standard. So don't underthink it. It is a constitutional standard. But and you can't ignore facts, as the high courts did in the NAD judgment. So in the High Court, in the NAD judgments, the court looked at market values, and it came to some quite difficult conclusions, and it just didn't sit right for the presiding judge, and said, well, that's actually stuff we're not going to look at. And the court said, well, no, that was inappropriate. So don't underthink it, but at the same time, don't overthink it. What you are doing is this. It's not an abstract matter. It's not some abstruse scientific calculation that has to be done. The reason courts can sit ultimately under the Expropriation Act at the end of this process, and it's always been a consideration for courts in these cases that they're sitting as super valuers. And, the judges looking down, I'm not a valuer. How do I sit as a super valuer? And the reason that is ameliorated is because what is called on for an administrator and what will later be called on for a judge if there's a deadlock is to make factual determinations. Start with the facts and build up from there. And you build up to an equitable balance, and then you arrive at just and equitable in the facts of that case. So you don't start with any preconceived notions at all. You don't start with any preconceived notions. You determine your facts, and you make your conclusions from the facts of that case. So how important is market value? It depends. Maybe it's very important, maybe it's not. It depends on what happens in that case. And that gets to the point that I think Judge Saldana, a debate that you had with learned friends from the Fatherland, talking about sort of where to start. And it's a difficult question that courts have struggled with after the Detroit judgment and the two-stage process. Well, do you still start with market value and then look at other factors as tipping up or down, that wax or wane the amount, and how do you actually do that? And I mean, we would point out that the Land Claims Court, where they've just applied effectively Section 25(3) principles, that they've started with market value. But ultimately, this court doesn't need to make that determination. It's not to make a determination of how the process must be followed, how you would run a particular inquiry in any particular case. Because it's not about where you start. It's about where you finish. And all you'd start with are making factual determinations. If you want to start with this fact or that fact or that fact, that's not the important point. What is important is how you deal with those facts and where you end up with them. And where you need to end up with them is, well, what's important in this case? How do we balance interests in this case? What can we say about this case? And furthermore, further principal point we've made is just to understand a very important shift that has happened under the Constitution, particularly, is that it is a shift to an inquiry based on interests. And so we've heard a lot about market value, and that market value is not conclusive. But the inquiry it goes further than that, that the inquiry is not one that's solely based on property rights. It's your rights and the value of those rights would be certainly a part of the inquiry, but it's an interest-based calculation. And the reason why we would point to this as an important point is because flowing from that, looking at the interests in a particular case, it can of course be that the amount that you get to is less than market value. We would say it can be a lot less than market value. It can even be null. And from our position, we'd say that null is a number. A zero is a number. It can happen. Whether it's rare or not, I don't know. I mean, it's maybe not. It's not a determination this court would have to make either.
So you fundamentally differ with the
So we would differ from them on this
So
issue.
you said no.
Yeah.
No, is no.
Judge Saldana, my client's not interested in a Pyrrhic victory of going, well, there's some sort of Pyrrhic victory of going like, well, it can't be null, but it can be 10 rand. Or it would seem that the null argument seems to us to miss the point.
No, but the important thing is that you get to know after an exhaustive and extensive inquiry on the facts.
Exactly. That's
and that's the distinction.
That's it.
So the other argument is that it's almost a signal to start at now. That's where you will end up.
Well, it is. And we don't. wouldn't go as far as to say that that anybody is directed to start at zero with these provisions. We'll get to these provisions, but effectively, as a general proposition, flowing from 25.3, we'd say that because you're looking at interests and the balancing of interests, we can think of examples where the consequence may be that the compensation is very low or zero. And the kind of example we would have, or the fact that, like in the Detroit case, where there was no value in the person's hands, maybe you've been put in a better position by the expropriation. So if I own a farm and it's quite remote, and now there's a road that's built right past my farm, and in the process of building that road, the road authority took a slither of my land, it would be hard for me to justify in those circumstances that I need to be expropriated for that land where I now have a benefit of a road. And there was, I think, the example made of, well, nobody wants a sewage works built next to them. Again, we would say it depends on the facts. If I own a business that generates a lot of waste, and the municipality builds a waste dump next to my property, that may be fantastic for me, because I was driving the waste across town to a dump previously. Now I've got a dump right next door. Of course that has to factor in. And of course it may mean that it factors in so much that I land up with very little claim.
Simply demonstrate the need for an open-ended factual inquiry.
So this is all that we're saying. So we accept that. There's an open-ended factual inquiry, and we'll get why we say that that's why we don't say that. And again, as another example, there's the case that came up in the Aaron case, which went to the Constitutional Court, which was about a new development, a new suburb being built. Internal roads have to be built, they were slightly wider than was strictly necessary just for that development. Should the developer be compensated for the extra piece of land? But there may be that a very compelling argument is made in those circumstances, as well as that. No, there's a benefit that you've got a new development that you've been allowed to build. You have to give up certain amount of land to the city that has the road authority for the internal roads in that development. And if some of those roads are slightly wider than they have to be, well, it serves you well because the people who are going to live in that new township are going to be well served by those roads.
So do you get to know on 12.3?
So that's
On 25.3.
So we would say that you can get to null on 25.3 in public interest and public purpose expropriations. It's not about how you characterize the expropriation. It's about how it bites in that particular case. And that factor.
25.3 could get you to null.
We accept that. Yeah, and we said these are the types. And then we're saying that it's not a sort of abstract acknowledgement. We can imagine circumstances where that is possible, where they're rare, or is not something that we would get involved in, but we can imagine those possibilities. But the point that we would note as well is that if you're if I can just sort of two other kind of examples which have kind of, I think, exercised the constitutional courts over the last while. So there was the Commando case, which was about the gentrification of Woodstock. And there was a court being very upset by the Constitutional Court being very upset with the city of Cape Town, looking and going, you have communities who've survived forced removals through the 70s and 80s, and now you're forcing them out, and it's a stain on all of us. The minority judgment looked at the matter in quite an interesting way and said, well, in those circumstances, there would be nothing wrong with placing an obligation on the developer to build low-cost housing, or perhaps even if you notionally, it might be so that you could expropriate land and to build low-cost housing. So if somebody's getting a benefit and a gentrification of a suburb, and as a consequence of that, your development has social ramifications, ripples through the community, well, that may be something that very well can be laid at your door. The very interesting judgment of Daniels versus Scribanti, which is the fact that there are sometimes you look at the facts of a case and wonder how a matter managed to get all the way to the Constitutional Court, where Mr. Scribanti, the farm manager, wanted to stop Ms. Daniels from fixing up her house that she held under the lawful occupier under the Labour Tenants Act. And
Well done to Ms. Daniel.
No, absolutely. Well, I think
That's
that's
got the constitutional
And-
court. You make very firm
Yeah.
statements without
Yeah.
historical
Yeah.
disposition.
I only say that in that the fact that Mr. Scrifancy maybe dug his heels in so much is peculiar. But I thank you that he did. Because we got a principle. I accept that. I just it's maybe my own sort of moments where we have moments of sadly lose faith in humanity. that somebody can do that.
Well, it's going to happen more often than not in the future.
Yep.
And that's why we're going to be guidance.
There we go. Yeah. So we can understand in those sorts of cases that there will be this downward pressure on compensation, and that the principle is flexible enough that we can include all of those sorts of cases. But if you are talking about an equitable balance, it goes both ways. And so the state would also then have to start acknowledging that in many cases, the compensation claim is going to be more than market value. And again, we would submit quite easy to think of examples where that might happen. For instance, if the land has a very strong emotional connection to me and my family. So under the old Act, there was an idea of a solatium. We don't see that really in the new Act. But if that's my interest, if that's me and my family have our interest in this land is an emotional connection that goes back a long time, well, that should be something that should be factored in. In the United Kingdom and Canada and Australia, there's this idea developed of business disturbance. So if I own a business that is very well known on a particular corner, and now I'm expropriated and I'm sent off somewhere else, it has an effect on me. My interest is not just in a trading space. It was that trading space. That's where everyone knew me. So that's it may be a case like that, or you might look at if you have something like servitutal rights. So if you have a servitude road across your neighbour's property, and your neighbour's property is now expropriated, and you lose your servitude road, putting a value to your servitutal rights is going to be very hard, because it's a piece of land that goes from here to there. Its only purpose is to get to your farm, or your property that's locked off from the road. It's got no inherent value. But if you take that servitude away from me, my servitude rate, I've now got to build a new road. That's my interest. My interest isn't the value of that you can go and put onto the servitude road. It's something more than that. I need to build a new road now. And that's something that is very different.
So, I understand the exercise that you've now done is that you've listed a whole list of more factors that can and may take into account in any specific matter that comes before an expropriating authority or a court.
Yes.
There could be any number of it. And that's why it's an open-ended list.
So I won't bang on about it.
Because there's a whole number. So
yes.
Some people might have a community attachment.
Yeah.
They've lived all their lives in a particular community, and now they've been sent off to Cape Flats when they lived in District 6 all their lives.
Yeah.
Those are the emotional attachments that people correctly make.
And
that's not listed here.
Yeah, it's not
the
listed.
Emotional attachment.
Yeah,
People is surprised it wasn't the Constitutional Court in 25(3) listed that, because that was one of the big issues about people's emotional attachment to a community, such as District 6, Freedom, East End in Quebec. Didn't do it, but they said there's an open list. That's the important thing.
So that's I'm perhaps banging on too much about this. Okay. So now you got the point. I'm just building up how there's a proper approach to 25(3) before we turn to the impugned provisions of the Act. But yes, that's precisely the point. It's an interest-based inquiry. It includes a whole lot of things, and yes, it's very important because land, for a lot of people, has particular pieces of land have a very strong emotional, familial, cultural connection points.
And the one thing that many people in Cape Flats feel most aggrieved by is the fact that they lost the sense of community. From whether it was District 6 or whether it was in Indaneni, the sense of community that was broken. that sense of community is broken, it's other very important socio-economic consequences. So when people talk about dislocation next to the rise of people being alienated from where they were, issues of unemployment, gangsterism, all of that. These things can't be foreseen in a crystal ball.
No, no.
There's no crystal ball in any of
No,
this.
of course not.
But we do get to understand and to feel the consequences of the dispossession
Yes.
that Parliament says you're going to take into account.
Yeah. So that's certainly right. But if we can just and just as a sort of last before we get to the particular provisions, let's go. So, similarly. We would also think that there are certain general principles that can improve, should have been in the Act, but they can be made as well. So, for instance, we would look and we'd say that it must be an important consideration that the state shouldn't overpay. And that's something, the amount of compensation that's going to be paid must also be equitable to the state. This isn't a sort of lucky day that just sort of, thank goodness they're going to sort of build a road past me and now I can sort of make a profit out of it. It's not how it's supposed to operate. You must be compensated, and you must be compensated properly. But it's not something special. It's different to the restitution cases, where the courts very often said we can and should be generous because of the historical impact that these particular claimants have suffered. If you're dealing in this sort of environment, there may be on the facts there may be reasons why there'd be an emotional connection, but you can't. The state shouldn't be overpaying. It shouldn't be an undue burden on the fiscus because of everything that happens. But at the same time, the state doesn't want to gum up the system. The state's going to have a legitimate interest as well in providing just and equitable compensation and fair offers, in order that you don't have everything landing up before courts, that you can actually sort of work through things quite effectively.
Both from their checks and balances in the state. So where there's fruitless and wasteful expenditure,
Yes.
someone's going to come after you for that. There will be accountability. Increasingly we're beginning to see that there is or there's a sense of accountability for financial wastage.
Yes, quite. Yes, I'm
There's
good.
accountability.
Yes.
Balance.
Yeah. Yeah. But yeah, thank you. I do accept that. Also, if we're looking at the state's interest, one of that, of course, you're going to look at the state's interest in land reform and restitution. That comes from the Constitution, and we'll get to how that weighs in a moment. But what mustn't be lost in this as well is that the state also has an interest in maintaining PE municipality, the various occupiers case, and so we've cited a passage at paragraph 45 of our heads of argument, not necessarily need to go there, but it's a PE occupiers, according to the blatant disregard manifested by racist statutes for property rights in the past makes it all the more important that property rights be fully respected in the new dispensation, both by the states and by private persons. Yet such things have to be understood in the context of the need for the orderly opening up or restoration of secure property rights for those denied access or deprived. Is that maintaining property rights isn't a fat cat provision. It's not something that you look into as like people trying to entrench previous gains and then refusing to give anything up. It's as important to the beneficiary of a land restitution or a claim or a land reform claim. If you go to a beneficiary of a land reform process and you go, here's a piece of land, now make something of it. If they don't have secure property rights, secure tenure that they can go to a bank and they can go to a bank and say, I've got this property, I can put up as collateral so that I can get money and I can make something of it, it means nothing. So giving people a land reform process where effectively giving them a right that's so attenuated and so weak and so open to that the government maybe coming back a little while later and saying, oh, well, you haven't done so well, we're going to put somebody else on the farm now. It means nothing.
Isn't that just a very narrow way we see land reform as simply giving people land. It's not simply giving people land. It's giving people land and providing post-settlement support. You know, that's what we said what happened in Zimbabwe. There's just no support. We collapse.
Yes.
Others want to ensure it doesn't collapse here.
Yeah.
So it's not simply that we give people the right restitution to a piece of land.
Yes.
There's a further obligation on the state to ensure that people have the capacity to use the land.
When
That then, I think, begins to negate some of the concerns raised by many people, is that people who've been restituted are going to be losing their properties.
Yeah. So, yeah, and okay, as it happens, my client, Mr. Klaus, has been doing a lot of studies about that, about the effects on communities of that, the fact that there isn't proper support. But support also can't last forever, perhaps. And you go like at some point, you're going to have a property, a piece of land, and go like, this is what I have. This is what I'm going to leverage this. And this is how me and my family, or me and my community, are going to manage to claw ourselves out of a dreadful position. And my client completely accepts that there is a dreadful problem that we still have in South Africa of a poverty. And it's in the replying affidavit. We're looking to praise the government for a lot of very good things that they've done. But the fact that there are 23 million people who are living in poverty of less than 1,300 rand per month per person. You have like that there are 10.2 million people in this country who are living below the food poverty bread line. It's something that none of us would want to sort of treat as anything less than completely unacceptable. Something has to be done. We accept land reform has to be done. But what we will develop as our argument is that doesn't mean that you can go to a particular landowner in every case and assume that because we're coming in with a good motive, because our motive is a very, very noble one, and it's a land reform motive, that automatically is a thumb on the scale on the side of lower compensation. Yes.
What is their thumb?
Sorry.
What is their thumb, and is their thumb lawful?
So what is sorry?
What is their thumb on the scale?
The thumb on the scale is we'll get to, is the provision, the impugn provision. Sorry, I'm jumping ahead a slide. I jumped ahead. That's what we say these provisions are, and by particularly 12.3 when we get to is that it picks out public interest expropriations, and it says, well, in these cases, and if there are these facts, then it can be null. Well, no, that's you say something. You say there's something special about public interest of it, and we accept that in public purpose and public interest expropriations, the facts may mean that it can go down a lot. But you're saying that no, it's not about the facts. The mere existence of our good motive means that that there's a thumb on the scale of less compensation, and then that's where there is a skewing of the equitable balance that we see in section 25.3 of the Constitution. So what we're saying is that there may be cases where, because of the particular projects that you're undertaking, that you would look and you'd go, yes, well, so if you have a farm owner who has created a homelessness crisis by evicting a whole lot of people, and the municipality comes along and uses a bit of his land on a temporary basis for an emergency housing scheme. So that farmer to then go and look to claim compensation, you might look and you go, well, that's rich. That seems to be quite a difficult position to sustain. So it may be so that the public interest in a particular case, the facts justify a reduced price, but you can't have an assumption that because we're not even looking at whether this person's to blame or not. The mere existence of our good motive is a factor that pushes down price.
We'll get to that debate later, but before you get there, can I turn you to your historical account
Yes.
in your founding affidavit? That can simplify it. David?
No. Sorry, the
Let me see if I recall it correctly.
yeah, no.
And this is just that we don't get the history wrong. or in my sense, there's no historical division. And you say Active Union 1910 had this potential that brought about inequality amongst the people of South Africa. But it didn't happen because 1913 came along very soon afterwards. But the notion of 1910 and Active Union as having this great potential for everybody in South Africa was a myth. Active Union was a myth. It was not there for black people. The Treaty of Vereniging came after the Boer War. And that was an agreement, there was a treaty of settlement between the conflicting parties, the Boers and the British. And then we go through a process of eventually a convention. Black people still included. In the Treaty of Vereniging, they excluded from the convention, and then you get to the Active Union. The Active Union was still an exclusion of black people.
Yes.
So all I want to point out is that there's a historical inaccuracy in that the Active Union had the potential to have dealt fairly with black people in this country. State no higher than that.
I wouldn't want to get involved in an argument about that. Certainly, there's.
I'm happy to have the debate about the Active Union. But all I say is that foundationally, when you raise part of the history of this matter, you've got to get the history right. Otherwise, we then make mistakes along with it.
Yes,
I'm not saying that my view is right. All I'm saying is that I don't read Active Union 1910 as have anything that would have created any equality for black people in South Africa.
No, that's
Even the very reasons for Active Union came about.
Yeah.
And the convention and the Vereniging Treaty.
Yeah. No, I mean, you would have had your entrenched clauses, but they would have been a very narrow kind of category of people. It wasn't. It wasn't a.
Very narrow people. Very narrow.
No, absolutely. No, I hear you.
May have 3 years later.
Yeah.
Later than that.
Yeah. I think when you actually sort of look back on a lot of these things and this sort of sadness of a lot of our history, and I'm certainly not the person to come and lecture any the sort of struggles of the sort of terrible things that came from our past. I'm not going to do that. I appreciate that. I like history. It's a good. So. And it's a substantive point for this case as well, because as the court, obviously even in NAD pointed out, is that in every assessment that you make, you've got to take account of the sort of historical the setting that we find ourselves in, and it's not something we can pretend or sort of turn our backs to, or sort of when it's not convenient, and so we would accept that. So if we start turning to the impugned provisions and why we say that they are disconsonant, the way they upset the balance that we see in 25.3. And the point that we make is that when you start interfering with the balance, what you land up with is undercompensation. And undercompensation is not compensation. So whatever, if you can, just and equitable compensation you can get to, but undercompensation can never be just and equitable compensation. That comes up in NAD as well, is that it's a constitutional standard. It is either fair and equitable, or it is not. And that's the quite sort of stark division that you would have in these cases. So if you landed with undercompensation, what you are landing with is unjust and inequitable compensation. And that is the consequence of tilting the balance. So it's as we said. So it's not like the circumstances between 25.3a to e. These are which are neutral. We now have very particular facts, and the particular facts that we would have in these cases. So we're just leaving 12 to e for the moment with the exclusion clause. But what we'd have in 12.3 is that the facts would be: is this a public interest expropriation? And then the speaker also told that it's particularly land reform type. That's the aim of section 12.3. So that would be our first fact. Is this one an expropriation for a public interest purpose? And then we'd look at, do the facts in this case, are they one of those factual scenarios that we see in 12.3? So 12.3a says it's unused property that's not generating income that you're holding for future use. Well, is this a piece of land like that? So what we see is that's what where these provisions are triggered in these, it's a particular factual situation that arises, not a circumstance. And
This alternative argument that by placing these factors in 12p it subconsciously, automatically results in a higher value being put on those factors when you weigh it to just an equitable.
yes. So we would submit that what would have to happen in every case is that an administrator, and we would say this, you can't just wait to say everything will be sorted out of the court. An administrator who is presenting a notice of intention to expropriate has to put in a value, an offer that is just an equitable compensation. So they have to, an administrator has to apply these sections. So these sections have to be presented in a way that makes sense to an administrator. And what we would say is that administrator, as much as you can put in may and all relevant factors and all of those sorts of things, there's a legislative instruction that these are things that we think are important. So they would have to make, first of all, the factual determination. Is this case that I have before me, does it fall within 12.3, within the purview of 12.3? What the consequence of that, we'll leave that aside. But first of all, am I in the purview of these 12.3 cases? And so you'd make, yes, it's a public interest expropriation. Yes, it's a piece of unused land that's not generating income and has been held to be sold in the future. You're in. Now that administrator would have to say, well, what does this mean? What does this mean in this case? And it's not about a corrupt administrator. It's not about somebody who's looking to take a chance. It's about the honest administrator who is sitting there and trying to do a difficult job and is told, but the legislature told me that this is really important. I can't just ignore it. And it's not about, further we'd also put in going, it's not about a jump from compensation that you would have been paid if it was a public purpose expropriation to null. It's not about going to 10 to 0. If the larger power includes the smaller. So what this administrator has been told, well, even if I'm not going to go to the null, I've got to reduce it a lot. And it can't be ignored. And I think, yes, they must still look at all other factors, and of course they must, and they must exercise their powers properly. But what they're looking at is, I'm trying to exercise a constitutional function, a constitutional standard, but the legislature has told me I must look at these things, and then how can I just ignore them? And even if the bold administrator every now and then does that, what you have created is a system which opens up to the honest administrator doing a difficult job, being placed in a position where he or she is looking and going, but Parliament told me these factors are important. What do I do with that? And looking and going, well, it must translate into a reduction into what I would have paid otherwise. And when I say would have paid otherwise, if it was a public purpose expropriation, so I raised the example that, well, if you're taking away my property to build a hospital, well, then I must be paid in full. But if you come and you say, well, it's a land reform project, well, then now suddenly there's this heavy reduction that I have to accept because there's a land reform purpose. And we would agree that there would no automatic reason why you would have that sort of distinction.
What we agreed earlier, 25.3 gets you to know very exceptional circumstances. 25.3 gets you to know. And so all the legislation then says is that when you consider 25.3 together with 12.3, these are the added factors that you may take into account. And much of the debate is going to be around may, and we don't just dismiss may as being optional. But you give it a particular weight after considering it. So when you say, let's look at the honest administrator.
Yes.
All the honest administrator has is a list of factors. each one, the standard, constitutional standard, just and equitable to inflict an equitable balance.
Yes.
Not these or predelection or predisposal to any one of the factors, so that clearly be unlawful. Into account, they not any relevance to particular
Yes.
circumstances. Some may.
Yes.
So they don't. He doesn't have to sit with the tick box exercise. It's a cumulative. It's a cumulative consideration of all the facts is what courts have to do all the time. It's an factual determination. You look at facts. Some are more relevant than others, but that's what you do.
Yes.
And so, why does it make it any different for an honest administrator
Because of the,
burdened with the responsibility to consider an added, not an added number,
yes.
but a enumerated number of facts?
So the important point to make is that, and why it's not good enough to say, but there's going to be a court at the end of the process, because the early decision has been made by, and the really important decision has been made by an administrator. As the Constitutional Court had pointed out repeatedly, an administrator is not a judge. An administrator works under a lot of pressure. If you place something perhaps more sort of woolly before a judge, you can have an expectation that you and or the judge that you can apply things in a lawful manner. You can understand that, well, that it's not just about this, that must also look at this, pull it all together and apply it in a constitutional manner. You can't have that assumption with an administrator. And not because we have a lack of faith in administrators, just because administrators aren't judges. And administrators work under a lot of pressure. And that's what the Constitutional Court has said, that if you're going to have powers that are given to administrators that are, then that's one of the reasons you'd have good guidelines generally if they're exercising discretions, that it's already a hard enough job. And if you give an administrator, under the sort of attempt to give them a guideline, you actually give them something that confuses the issue even more. That's a problem. Because now what you've done is it may be well-intentioned, who knows? I mean, that you've created that now there are these guidelines, and the honest administrator is going to be sitting there looking and go like, I don't understand, but I have to do something.
Hold on. When the administrator says, I don't understand, what's the first thing you do? I don't understand. You then read it again, and if you still don't understand, you get proper legal advice.
Yeah. Well,
So what I'm saying is that these administrators are not these helpless human beings who have no intelligence, and they're simply going to be with all their predilections and their...
Judge, that was definitely not what I was suggesting. I deal with a lot of administrators in different spheres of government who are unbelievably hard-working, capable people. That's not my...
But isn't that the standard of the administrator that we must be dealing with? An honest administrator.
Yes.
An administrator who works hard.
Yes.
An administrator who will get proper legal advice when in doubt. Doesn't understand the legal provisions. Doesn't understand how the regulations work. Isn't that the administrator that we must be considering, rather than one who, as you say, throws his or her hands up in the air?
It's not about somebody throwing their hands up in the air. The point is that when you have a power that has been given to an administrator that they have to exercise, you set it out for them properly, and you give them guidelines where there need to be guidelines. And so if there were proper guidelines and it met with Section 25(3), we would be very happy about it. And we think that there are guidelines that could set out very well to help an administrator. But with some of that, what happens in these cases is something this national person that with this administrator that we're thinking of is also going to have another complication, that they've now got the Property Valuation Act and the regulations under the Property Regulation Act, and that basically takes the 25(3) individual functions and says this is how you calculate each one of these. And there's a property value, valuer general who's created, and there's under regulations like how you would calculate the land use. Anyway, so they have to do all of this stuff. Yeah.
Property valuations is not 12(3). And actually, there will be a fight somewhere else.
Yeah, all I'm saying is that it's a hard job. It's a hard, nobody needs a provision that makes it harder. And we submit that that's what these provisions do. 12.3 make it harder because they effectively lead the honest administrator into a position where Parliament has told me there's something special about these cases. I have to acknowledge that the Parliament has told that there's something special about these cases. And not dishonestly, not throwing my hands up. Well, Parliament's told me there's something special, so like, who am I to disagree? Maybe I don't agree, but who am I to disagree? Parliament's told me there's something special here, and that in these sorts of cases, and it's not about going to zero every time. It's cases where you go to null, maybe very rare, but in every case, these provisions apply. In every case where these provisions apply, there is a pressure to reduce the price. Maybe not to zero, but a pressure to reduce.
What is the pressure?
Because you're told that these factors are significant.
What's the pressure?
That Parliament has told me that these are factors that require. But no, that's with respect that's then what is the provision for? Then the provision means nothing.
I'm really trying to understand is that what's the concern about making people's job harder? Is it really making people's job? Parliament is to make people's job easier. It's like saying to judges, we're not going to give you complicated issues to deal with. We're going to make your job harder. And the administrator gets a job description, and the job description says, honestly, ethically, and you apply, he's well minded. What more can we ask of the administrators?
Yeah.
Otherwise, we might well be dealing with some liminal biases. And that's the danger. We must really accept that administrators are genuinely those who take their job seriously, as honest, ethical, and they will get advice when necessary. And if they don't get advice, they're going to make mistakes. And if they make mistakes, they are going to be challenged. And they will end up in court.
So the point that we would make is that mistakes are going to be made and mistakes can be corrected. But if the legislation itself is the thing that is luring people into mistakes, we're not trying to make people's jobs easier, or we're not trying to say that their jobs can't be hard. Don't run interference. Don't make it harder for them and tell them that, and now I must look at this, and I'm told Parliament tells me that these are really important things, and I must look at these, and it's a pressure. It can go all the way to zero. Of course, I need to look at it. As the honest administrator would look at those and go and that there's a pressure that there's a downward pressure on price. And an administrator who didn't consider that would be ignoring an indication from Parliament. And that this section means something, judges. What Parliament has said is, sure, it's all enough cotton wool sort of shoved in to try and to sort of make it look less innocuous. But the administrator has to make a decision, a factual decision, that are the facts of my case, do they trigger these circumstances? And then they're going to have to look at what do I do with it. And for any administrator to look and go, Parliament thinks it's important, but I don't really think so. That's with respect to is something as you're luring people into mistakes.
That's not the approach. The approach is not where the administrator says Parliament thinks it's important, I don't. The administrator's approach must be Parliament has set out a number of facts. Does it apply or does it not apply? If it doesn't apply as the administrator, I'm well entitled not to take it into account. Where it applies, I'll take it into account. But it's not throwing hands up into the air.
It's not about throwing hands up in the air. It's about the determination. Is it triggered or not? So if it's not triggered, well, that's fine. Or then we're not in a 12.3 scenario. The problem is that if those provisions are triggered, as a matter of fact, on the facts of your case, the administrator is going to have to look and go, what do I do with this now? And if you go like, I know I need to look at all relevant factors. Surely one of the relevant factors I need to look at is Parliament has told me that when the intention is a land reform process, that counts for something as a discounting factor. That when it is land that is not being used and income generated, and it's and just been held for that. That means something. I'm been told it's relevant. I've been told it's something, and it's like, and I can look at all the circumstances of the case, and I can go backwards and forwards. But I've been told it's relevant, and it doesn't matter whether it's relevant or not in a full analysis. Parliament has told the administrator that it is important, it is relevant, and the administrator would have to give attention to that.
Parliament is still the administrator. It's one of many relevant factors. And that is Parliament said in 25.3. Parliament says here other factors that you may wish to consider. And I don't know how we can ask of the administrator when dealing with legislation.
Yeah. Well, can I just, if we just get to with 25.3 and perhaps what it actually means, and so one of the things we go is that the administrator struggling to understand what it means, and we'd submit even a court's understanding, is that with respect, the state respondents can't really tell us exactly what these things all mean.
Sorry, what is
Whether 12.3. So if we look at the Speaker's affidavit, it's the Speaker's answering affidavit to my client, IR Legal. It's 005276. And so it's paragraph 15 of that affidavit. And so it says, the Speaker says section 12.3 doesn't contradict 25.3 of the Constitution. It gives concrete legislative content to it. So it's doing something. Just be aware it's concrete legal content. Remember, what is that concrete legal content? It provides that no compensation may be just and equitable if land is expropriated in the public interest, but only having regard to all relevant circumstances. It then lists examples. And then it says, so now what we're told, this concrete legislative content is actually just giving examples. That seems perhaps slightly less robust than concrete to me, but that's we don't need to quibble about that. It starts off. These are just that's concrete, but it's just these examples that we're given. Then we go a little bit later in that same affidavit to paragraph 68, and that's 005290, and we see that the Speaker then continues. 12.3 requires all relevant circumstances still be looked at. It does not prescribe. It merely provides the subject to other relevant circumstances. It may be just and equitable for no compensation to be paid where land is expropriated in the public interest. They're just examples. Now they may be taken into account. Next paragraph we see again, it's identify examples. The concept that special attention may be required. And then we go in the next paragraph where it says a special consideration should be given to these factors. Now, so with respect, now we got to they're just examples. They may be considered. They should be considered. So now we got to that's where we are with the Speaker, and if we start looking at the heads of arguments on the matter as well, that we'd have. Sorry, excuse me. So we would submit that is precisely the issue with these provisions, is that there's yes, when we accept this, that there's may and that all relevant circumstances still come in, but that if the section says something, so there are two options here. The one is that the section actually just doesn't actually say anything. It's just a kind of like, well, consider these examples. Maybe that they have relevance, maybe they don't. And then you'd look and you go, well, I don't know. Yeah.
When you look at the section says may,
Yes.
may,
Yes.
and it says but not limited to.
Yes.
So again, the section takes us to maybe,
Yes.
not must, and it's open-ended factual inquiry. So if you want to look at the section and apply the section, you cannot then lead in and focus only on one issue and apply this equities made
Yes.
when the section says is made.
Yes. But this is, with respect, we would submit that the difficulty with these provisions is that, okay, so now you got that they may be relevant. So now you're putting apparently a discretion in the hand of this official in a non-discretionary function. It's a constitutional standard, but anyway, there we go. Now that we've got that as an interesting conundrum. But for that person to determine, is this a case where I should or shouldn't? I know I may look at a lot of things. It's a very wide power I have. I've been told, and I know I may look at, now I'm told I may look at these things. Well, I knew that anyway. So thank you very much, Parliament, for telling me about a power that already existed. If that official now wants to go, well, this is this one, with the case that's before me, is this one of the cases where it's important, that it actually is important for me to look at the purpose? And we would look and go like, oh, how would the administrator be able to determine what the principled reasoning is from this? So for instance, if we look at if we turn maybe to the A to D factors for a moment. So factor A is that the unused land is not generating income that has been held for future use. So you can look at it. Now, an administrator would look and go, okay, well, because that's triggered in this case. And in the founding affidavit, Mr. Krause, my client, points out, he says, well, what about the case where somebody inherits a piece of land, they want to develop it, but they just don't have the money at the moment. It's unused, it's not generating income, and it may be developed or it may be sold at some sort of future point. So that's hit by 12.3a. And the answer that is given is, no, that's not correct, because the expropriating authority or the judge or who's ever looking at this thing doesn't have to take it into account. So effectively what we read in that argument is, well, what about this example? And the answer is given, well, obviously not that example. Of course nobody would apply it in that case. And we go, well, why not? And not any sort of deliberately obstructive way. What is the principle? Like, what is the principal category of cases that this actually becomes important? And the minister says, well, it's about land speculators. I don't see that there. This affects all land that is unused and not generating income and that has been held to later. Everybody who owns a house and who owns a piece of property is a land speculator. Now, everyone is concerned about the resale value of their property. There's nothing wrong with speculation. In FNB, the West Bank case, the Constitutional Court Judge Ackerman still said, there's nothing wrong with speculative ownership. It's not something that you would look and you go that there's something inherently that does dangerous about it. So if the administrator is looking and going like, I'm told by Parliament that I should be looking at this as a very important factor that I should be taking into account. I know I don't have to. I'm going to, but no, actually this is one of the kind of cases that Parliament is so worried about. And that's the problem with these provisions, is that you have a general statement. So it's a public interest expropriation. Okay, fine, it's not important in every case. And I don't have to follow it in every case. But how do I know when I should be and I shouldn't be? It's what is the principled basis that I'm being put that is behind this guideline from the legislature?
Isn't it relevance? It says relevant with regard to all relevant circumstances.
Yes.
So if the factor and circumstance is relevant, you take it into account. If it's not relevant, you don't take it into account. It's not valid, not taking into account circumstances for the sake of taking it into account.
Yes.
It's taking it into account if it is relevant to the facts of that particular case.
But then with respect, then the provision does nothing. Then it says nothing, because that's the usual test. So you're telling me I can look at something, but it may or may not be relevant. You look, what use is that? The provision says nothing. It adds nothing. It subtracts nothing. It tells me I can look at a factor, but after I've looked at it, I must determine it may or may not be relevant depending on the facts of the case. Well, that's what's happening anyway. Now you've created 12.3, you've created a provision that is mere surplusage. It does nothing. Because we all know that it can go to null. We all know that in the public interest, if it's relevant in that particular case, it can go to null. That maybe the use of the property in a particular case, and the particular facts of that case, would be a downward pressure on the compensation amount. What is this provision doing? What more is it telling us? And if the answer is nothing, if the answer is that this is just mere surplusage, it's pointing people to things and going and just sort of, oh, there we go, walk away, and sort of, we're looking at it's very confusing to me why you'd want to do that. Why you would have a legislative, what is your legislative intent by legislating a provision that you'd look and kind of go, oh, by the way, have you considered? And sort of look, I'm not telling you it's relevant, I'm telling you it's irrelevant. I'm just sort of like, oh, by the way. That's keep that for the inter-office memo. Or the guideline document or something else. This is legislation. It's doing something. We have to interpret it to be doing
Guidelines
something.
in the office.
If you're going to have,
Can you
if it is,
imagine how unconstitutional that would be?
there's nothing wrong with guidelines with respect.
Wow.
No, there's nothing wrong with published guidelines. They happen the whole time. Policy
office.
documents
Guidelines in the office.
in any office
You'd be back before us in 6 months.
No, if
Because then we don't know.
No, but
All
if,
of a sudden there's some bureaucrat who's decided, you know what, I'm going to list a couple of guidelines. Mr. Wilson, there can't be
no,
guidelines.
with
in the
respect,
office.
there are guidelines and policy documents all over the place. As long as you don't restrict the discretion of a person, there's nothing wrong with an indication to an official who's exercising a discretion, and if there are guidelines that are available of how a discretion will generally be.
We're not dealing with discretion.
So we're not. I'm just saying. I'm not going to get.
We're
not dealing with that case.
We're
Absolutely.
not in the realm of discretion. But if somebody internally in the office starts throwing out a list of facts that probably hasn't been exposed to, hasn't been exposed to here, they'll be saying, what's going on?
No, but
Every province will have, every municipality will have their own different guidelines
Of course.
internally.
yeah.
That would be problematic.
Yeah, no, that's but if there's not, this isn't even a guideline, by the way. What the interpretation that you'd get to if on this understanding of Section 12 is not even a guideline. It is basically like by the way, did you know you can? It's an utterly meaningless statement. It's not telling an administrator. It's not helping an administrator. It's not telling them anything. It is just it's a chappie's wrapper. You can consider this, or you don't have to consider it. No, I'm saying it's advice on a chappie's wrapper. It's meaningless. It doesn't matter. It's like you can look at this thing, but it's just like.
You're saying Serbage, chappie's wrapper, you know. That makes it unconstitutional.
Because it's legislation and it must mean something. And as soon as it means something, it is telling the person that there's something special about these particular facts, that there's a downward pressure on compensation when they are triggered.
But if it's Serbage, if it's already there, it's on the chappie's wrapper,
Yeah.
what makes it unconstitutional?
Well, what's your legislative intent? Now, you have passed legislation that is. Yeah, so a rationality. What would be the rational connection between your power and your legislation and your purpose? What are you doing? There would be a fundamental irrationality in a provision that was deliberately passed and deliberately introduced into legislation in a way that it was designed to mean nothing. To mean nothing. To be merely that is the chappie's wrapper legislation. It can't be that.
Light of the argument.
No, I'm not. I don't say it's that. I say it is something a lot more than that. What I'm saying is that if an interpretation is reached that suggests that this section is just an indication to an administrator that look at this, it may be relevant, it may not be relevant, then it doesn't mean anything. Because if the administrator knew that already. They already know they must look at the use of the land. They already know that when they look at the use of the land that it may be relevant and it may not be relevant.
So
but why are you picking out this particular land
use?
use?
It's more than surplus.
I'm saying it's more than surplus. There's a reason why they chose this particular land use and said, consider this particular land use. They haven't said we as the legislature think that's a very important downward pressure on the compensation amount. So anyway, that's I think that's perhaps getting a, and that's I think I made the point. Perhaps I don't need to flog that anymore. But if I can just really did mean to be completed by lunch. I think I'm.
Are you done?
No, I'm not. I'm just because I need to get to 12.1e and I need to get to the 12. It's a few minutes. Can I perhaps? We've got 10 minutes. Can I complete 12.1? See if we go the 12.2e.
Is enough time for you?
I think that's perhaps I would need to kind of. I know we have 5 days, but I don't want to be the person who's completely responsible for holding things up and running over. So.
Do you want to break?
No, I mean I'm happy to carry on. Yeah. So, okay. So yeah, jumped ahead, but okay. So a point that I've made, what I just want to sort of highlight is that it's not about courts. It's not about cases about that. It's a good enough answer for the state respondents to say, don't worry about this because it'll all be fixed up by a court at the end. So we're saying that we would point out that the issuing of a notice of intention to expropriate, that Section 7 notice, includes an offer. That offer is made on the basis of a just and equitable determination, and that notice has a whole lot of other consequences as well that have direct legal effect and would fall within the Gray's Marine type of affecting rights situations of that. And there's the Kohler case, which is referred to in our heads, which is under the old 1975 Act, where a notice of intention to expropriate was treated as administrative action, and so we'd say that it's not just about that a judge can make sense of this. It's an administrator has to be made sense of this, and that's where we point to the case that an administrator is not a judge and shouldn't be treated as the same. Excuse me. So that's, and the third point we'd also point out is that a person who's affected by an expropriation is entitled to fairness throughout the process. So even if it is a case where it can be fixed up by a judge afterwards, the person who's affected by it is entitled to fairness throughout the process, and it's a principle from Slagment and other cases. So it's an expropriating authority must be able to make sense of this, and we'll look at that. Okay, so 12.2e was the point that I did, the provision, and this is the exclusion provision. And so if we look at the provision, importantly, what we'll see is, read things here. So 12.2e, so and this is also quite clear in this provision at least, that it's a provision that's directed at the administrator. So 12.2 starts off, in determining the amount of compensation to be paid in terms of the Act, the expropriating authority must. So 12.2 is a provision it's not to a judge, it's to an expropriating authority. So the person who's busy making that determination, they must not. So it's that, unless there's special circumstances which will just enable to do so. And then we have 12e, so they must exclude anything done with the object of obtaining compensation, therefore. And it's that provision that we've again that it's one sort of both genuinely look and shrug our shoulders and go, what does that mean? And what does that cover? It seems ridiculously wide on a sensible interpretation. And we'd look at kind of just so we had our argument in our heads of argument was initially was that there was a contradiction between 12.2d and 12.2e. So when we said. So we have no problem with the other exclusion provisions in 12.2, and particularly 12.2d. We have no problem with it because it's a sensible provision. It says if you have a piece of land that's been expropriated and if you start making improvements and if you don't have the permission or the agreement of the expropriating authority, or that you're fulfilling some sort of other pre-existing contractual obligation, well then you can't claim compensation for. Wood just points out something, though, that sort of is that as a result of, if the approach is going to be taken that compensation must be finalized before the Section 8 notice is served, Section 12.2d is meaningless again. And it's one of the problems that we're not involved in the Section 19 issues, but it's one of the problems with getting the red pen out in an act like this and trying to change things is that you have like rippling effects like 12.2d. Because 12.2d says improvements made to the property after the date of the notice of expropriation was served. So that is the Section 8 notice that is served. But where is this provision applying? 12 the introduction is where does it actually find application? It's when an administrator is determining compensation. So this provision, when it's actually going to be applied by an administrator, is when an administrator is deciding is sending a Section 7 notice. And so now what 12.2d says is when you're sending your Section 7 notice, you must exclude everything that was done after the Section 8 notice was sent, which is a notice that can be sent in the future, maybe. So this provision it would never apply.
But you're not challenging.
I'm just saying I'm putting it out, and that this is one of those cases where I get to throw my hands up and just go, there we go, it's a hard question. It's I throw my
Rather shrug your shoulders.
and I get to shrug my shoulders and walk out. I point it out to you and say that this is the difficult question that you're left to deal with, and I leave it. But it's one of those rippling. So there you have 12.2d, a sensible provision that was initially introduced, but because of the sort of late stage change in your drafting process, has now been left having no application ever. And now you're left with 12.2e, and you're saying anything done. So there's no temporal restriction. I mean, it would have to be before the Section 6 notice, Section 7 notice is issued, because that's what the administrator will be considering. But it's anything, there's no temporal restriction done with the object of obtaining compensation, therefore. Now, with respect to it's like, and we told this is to avoid abuse, but that's not what it says again. And to look and to go, and I'm told that this is one of these cases where the administrator is told, I must exclude this. And then unless there's special circumstances, I must ignore this. Anything done with the object of obtaining expropriation, therefore, and you look and you go, well, what about, I've heard in the local pub that my farm or strip of my farm is potentially going to be expropriated to be part of the Kucha development, the IDZ development, so in the Offit case. Sitting around for a long time waiting for something to happen is not happening. And now I might look and I go, but I need a new shed or a new garage or a new whatever it is. It's a bit of a waste to build it if my property is going to be expropriated relatively soon. But you know what? I'm going to build it anyway, and if it gets expropriated, I can claim it will increase my compensation. I did it. And it's not the only object that you have to have. I did it with the object of going, I will get compensation for this. What happens if I look and with respect, we all do things to our properties the whole time with the intention of getting compensation in the future. We all if we do. If anybody who is selling their house, they're going to, well, not anybody, but a lot of people are selling their house. They're going to look and they're going to go, of course they're going to fix it up. Of course they're going to make it more marketable. Then what they're saying here is that somebody does something.
You hear it in the bar. See, this is what you hear in the bar.
No.
Hold on.
No.
This is what you hear in the bar. You know what, the property is going to be expropriated, and I'm going to build a guest house on it in the meantime.
So
you have to come and explain.
Of course. So we accept that category of case. I mean, so if somebody is taking whatever, if they take, so you look and you kind of go, the person you'd look at and you'd go, you're being cheeky, and you deserve to be punished. But that's not what the section says.
Well, what is the section say?
The section says anything done with the object of obtaining compensation. So it's not about the person who decides to build a guest house. If they do anything, and they said that must be excluded from the compensation. I put a new path up to my front door, and it makes it nicer. And actually, people have said and it cost me a few $1,000 rand or whatever, but it actually increases the value of my home quite a lot. Anything that is done at any time when I knew, presumably at the time when I knew that there was a non-negligible chance that my property might be expropriated in the future.
That's why it's anything, so it's wide enough either going to be included or not. If you're just building a patio driveway on your property,
It must.
but if
The
you're
expropriating
going to build a
authority
guest
must
house,
not.
you're going to have to come and explain.
The expropriating authority must not take account of. And then, so that would say you must not. And the only way that I can get out of that is if I, as the property owner, come along and say to the expropriating authority that there are special circumstances that make a just and equitable that should be considered the same. It's not just anything. And so we submit that what you have here is you have a provision that is obviously overbroad. And we accept that there might be a category of cases where it is very well intentioned and it should apply. And what we submit is that if you had the 12.2d exceptions. So now you're saying so now if I have gone and if I built something and maybe I spoke to the expropriating authorities and said I'm going to do this, and they said yeah that's fine. Or what if I built something and it actually has value to them? So I've built something. I didn't even talk to them, but it's like the thing that I built, the shed or garage or whatever, it actually serves them very well. I didn't get their purpose for it, and now I get told that that's something that the position, the sort of starting position that the expropriating authorities are told you must not take account of this. And there you have it. And then suddenly be up to me to go and do the running and to say, no, but there are special circumstances. And you go, well, what would you have as special circumstances that would, that the authority, with special circumstances, not just any circumstance, there must be something special about it. So with respect, that's the 12.2e problem. So you land up with, so let me just have the point that so just point out, so the minister's heads pointed out, and perhaps making the same point, Judge Sodan, you made, that what they're looking to is that they want to avoid things being distorted by artificial, unlawful, speculative, or opportunistic facts that do not properly form part of a just and equitable compensation. Well, we're looking to go, well, then, if that's what you meant to say, why didn't you say it? I mean, it doesn't seem that hard to kind of create the sentence to kind of bite where you want it to bite. Why have you said anything that with the object of compensation if what you really meant is distorted by artificial, unlawful, speculative, opportunistic facts that do not properly form part of a just and equitable compensation? And this wouldn't have been hard to have done it, and you've chosen a deliberately vague, a deliberately broad application, and we'll submit that is something.
Why do you say it was deliberately?
Well, sorry, not deliberately. I overspoke. Sorry, maybe it is time for lunch, but I'm getting careless. Thank you. If I can finish just one or two points, just as 12.4 when I come back on some B to D, and I will try and be as quick as possible, wrapping up after lunch. Thank you. Thank you.
You get promise with time, and then you underperform with time. You say, I'm not going to be that long, and then you're going to do it. You just have to go through 12 till interview. You haven't gone to 12.
Trim these. Thank you, Joe. Sorry, I've just got some of my stuff. If I can just go back for a moment, just to refer you to just things that I've covered already, but in my head of argument. The fact that an administrator, an official, stands in a different position to a judge when interpreting something like these provisions, it's dealt with in the Darwood case, and it's in our heads of argument, page 35, paragraph 76. We've got the extracts there. And that's Darwood's dealing with the discretion. We had said the same principle applies even more. I mean, it's affords you all right. You're dealing with a constitutional standard here, and it's talking about the importance of guidance and a difference between requiring a court or tribunal in exercising a discretion to interpret legislation in a manner that is consistent with the Constitution and conferring a broad discretion upon an official who may be quite untrained in law and constitutional interpretation, and expecting that official, in the absence of direct guidance, to exercise the discretion in a manner consistent with the provision of the Bill of Rights. So officials, administrators would submit that's an established principle that stand on a different footing, and without any affront to any official or class of officials, we submit that's been confused in this case, because we submit it's been confused in this case with the impugned provisions, because in an attempt to give a guideline, and particularly sort of something like 12.1e, which I was dealing with just before lunch, you've created this broad statement that covers a lot of ground, and an official now has to kind of decipher out of that, well, this is guidance, this is a provision that I have to follow, but what is the principle at work here? So if you say that it's anything done with the object of compensation, well, it can't be. It can't be anything. There must be certain types of things that you would be compensated for in those circumstances. But how do I discern? So I've been given this guidance. It seems to be too broad on its face. I have to try and interpret it properly. But what is the principle here? And with respect, we can't see it. So, for instance, if we turn, and perhaps we can turn immediately to 12.3a. Sorry, Judge, I have scattered my notes all over the place. Very well done. So 12.3a as well, which is, so we're told that it's land that's unused, it's not generating income, and you're holding it to sell it. So that again, that covers an incredibly wide category of cases, but and obviously it is not applicable to all of them. But if we look at we're told that these aren't things you can ignore, but just whatever you have the public interest criteria that we looked at, you're told to consider all relevant things, including. So what the legislation must be saying here is that these are relevant to your consideration. We're not telling you how to weigh them or anything like that, but these are certainly relevant to your determination. And how are they relevant? They are relevant as a downward pressure on compensation. So these are things that they can push to null, but they are a downward pressure on compensation. And you must, there's no discretion, at least in that part as well. You can't say, well, I'm not even going to look at that because I don't think it's important. You're told it's relevant by the legislature. You must at least consider it. And if you consider it...
factors which may be relevant.
Yes.
Well, why do you ignore them all the time?
Excuse me, sorry.
Why do you ignore them all the time?
But so with respect, the problem with 12.1a, or 12.3a, we would say, is that even if you could get to the interpretation that the Speaker gives us and says, well, what that 12.3a is really aimed at is unused speculative land. So,
you know, Speaker's interpretation,
I understand.
not relevant. How can we take it into account when we have to determine the interpretation of these provisions? Let the Speaker tell us what's your interpretation.
Fully, and
You've done it all. You've done it earlier when we left you, or we thought lunch.
No, so with respect, the submission was never intended to be that we must take their view of what the section means. Of course that's irrelevant. The point that I was making when dealing with how the Speaker had dealt with the provisions was that So we're told that, oh, well, you figure it out. It's not that hard to figure out. And with respect that the speaker can't the speaker goes between different versions. So, well, the point is our submission is that these things don't render up to any meaning. And with respect, it's confirmed by the fact it doesn't, because not even the speaker can explain to us.
The speaker's interpretation.
I accept it. I'm not trying to.
Mr. Boston, why do you keep on hanging it on the speaker's?
I take it no further. Okay, so but if we then look at this provision and we say that however we interpret, so there's a category of cases where we're told it's relevant, I must look at it, but you can look and go, but why am I looking at this? Why is it important that that I must look and consider as a downward pressure unused land that isn't being used to generate an income that's been held? So what's the purpose of my inquiry here? You told me to look at this. I've looked at it, but now I don't know why I'm looking at this.
You don't know why. It's one of the factors to take into account. I mean, it's not.
No. With respect, you're told to look at the use of the land. And you've told me that you haven't told me to look at the use of the land. You told me to look at a specific use. And you told me that this specific use is something I must consider because it's relevant as a downward pressure on the compensation amount. So it's not like 25.3 with respect. You have not referred them to circumstances and said, go and assess the facts. You've given a direction to go and look at a specific factual situation, and you've told them it's relevant, you've told them it's important. And now the administrator has to look and go, but why? What is the principle? Why is it important? What is wrong with holding land for future sale? Why would that be a justification in itself as a downward pressure on price? And with respect, we say, well, we can't see it. And
maybe the administrator
sorry?
may see it. Maybe the administrator may see it. I mean, we really can't be second guessing in this process.
With respect, I think I've made the point that perhaps once more, but it's you've told them to look at something specific.
Yes.
And so I don't understand how somebody would understand that provision. I'll leave it at that. I've been wrong many times before.
Well, we've all been wrong many times, but it's not a second-guessing exercise. We're trying to really to make sense of this legislation.
Absolutely, Judge. But that's precisely the point, is that it doesn't help to give a guideline that only causes more confusion. And that's what this provision does. You've told me to look at something. I'm looking at it. And it's a downward pressure, but I don't understand why. I don't understand why, with respect, and how an administrator can do it without any disrespect to them, perhaps they're not clever and smarter and have more insights into these things. I can understand that there might be cases where the fact that the land is not used is important. But what we also see from the Ace versus Mzisa case, which was under the Labour Tenants Act, is that very often the way that land is being used or abused or neglected, it's already factored into the price. You can't double count it. But so now you've pointed to me to this thing that this land isn't being used. You told me that's very important. And there's a downward pressure, and with respect, we don't see why that should be. And that even if you could extract some sort of meaning from it about speculative land use, I don't understand what is speculative land. What is wrong with speculative land? In FNB, the Constitutional Court said, a speculator has no less a right to ownership in goods purchased exclusively for resale merely because she or he has subjective interests in them, but sees them only as objects that will produce money on resale. With respect, somebody who's holding a piece of land for resale, their interest in that land is its market value, and that's their only interest in it. And now you've told me that I must look at that, and I just don't see why it would change anything to come and look at it any more than that. And what is the importance of the fact that they're holding it for reason? What if somebody was holding a piece of land that they didn't intend to sell? What if you had a notional farmer had 10 farms in a row, wasn't using any of them, but said, I'm not selling them just because I don't want to? That land's locked. That land is locked out of agricultural use. And there you've got a problem. That person's not hit by this provision. It's the person who does want to sell the property, as if there's something wrong with that. and there's something wrong with holding property to make a profit. And so the section's overbroad, and it's not a guideline. It's an attempt to make a guideline that only manages us to confuse. So that was 12.3a. So 12.3b. So this is the provision about one's organ of states and expropriating land from another organ of state, and the logic of the provision would appear to be, well, if it's one organ of state against another, it's effectively money coming out of one pocket and going into another. And we submit that's with respect not correct, because of what Section 41(1) of the Constitution says, where you've got different spheres of government that are distinctive, interdependent, and interrelated. And we particularly raise the example of municipalities. They hold land, very often is not core to their need, and they might want to sell it. So then they can only sell it if under the Municipal Finance Management Act, if it's not core. And as soon as they sell it, though, what they're effectively admitting that it's not core, well, that makes it susceptible to be expropriated by another organ of state. And that's deeply problematic to the distinctiveness of that local government authority in that case. And just a City of Cape Town, it's not in our heads, but City of Cape Town versus Robertson, which is the Constitutional Court case, and it speaks about the enhanced status of local government, and that the Constitution has moved away from a hierarchical division of governmental power and has ushered in a new vision of government in which the spheres of local government is interdependent, inviolable, and possesses the constitutional latitude within which to define and express its own unique character. A municipality under the Constitution is not a mere creature of statute, otherwise moribund, save if imbued with power by the province and national legislation. So now, if you have a piece of land that is owned by a municipality that's not core to its requirements, and it wants to sell it, and another organ of state comes in and says, well, we want to expropriate that land for a public interest, that has an asset value to that municipality, no less than to any other person. It's an asset value in the hands of the municipality. It is part of the municipality's inviolable space that it holds it, and to suddenly say that there's no need for compensation in that case would undermine the unique and status of local government in those circumstances.
Municipality, Mr. Bolton gets a special place with regard to the consultation process.
Yes, it does. Yes, we understand that.
So they will be served with the papers, they will be able to exercise, will not be caught by surprise.
Well, in this case, they would be the landowner as well. So
yes, but interestingly, none of the municipalities
come
and challenge this.
So we certainly in this case would be raising something that it would be on behalf of the municipalities. They haven't done it. I couldn't take that, but we're something that is a fundamental problem. Excuse me.
They didn't share your concerns.
Well, we would submit that it is a matter of law. So whether they're concerned or not, there's a legal determination.
But their balance sheet, they're not concerned, because part of it what you raise is that it's on the balance sheet. They're not concerned about that. They understand. They appear to be understanding the nature of the legislation.
Well, I will freely admit I have no answer to the fact that no municipality has decided to join in these proceedings. Perhaps I don't understand why, and you can draw whatever inference you would like from it.
As long as your client, they'd be here before us.
Excuse me, sir.
If they felt as long as your client, they'd be here before us.
Yeah, well, if that's the inference that's made, and that the municipalities don't mind. But the point we would still make is that even if every municipality in South Africa turned back and said, well, we don't mind. And that doesn't change the fact that the lawfulness, unlawfulness question that has been raised before the court and that must be dealt with.
They actually considered this piece of legislation.
Yeah. But the point is, even if they had considered it, I'm sorry, I'm being flippant. That's one of the terrible habits. So even if they had considered and they said, for whatever reason, that we don't want to be the ones to challenge, or we're not going to challenge it. It doesn't change the fact that a lawfulness question has been raised before the court by my client, and it's a question that needs to be determined as a lawfulness question. And it's the fact that municipalities aren't bothered by it, or it's something you can take into consideration.
It's one of the factors that is placed before administration. That's all.
Yeah.
It's one of the factors.
As you told us,
One
relevant.
of the relevant factors that must be taken into account. What's the unlawfulness of it?
The point again would be is that we would submit that the problem with all of these factors is that they don't identify a principled basis on which you would identify when these I'm told it's relevant, but why is it relevant? What is it? What happens with this relevant piece of information?
3A says
What's it?
may be taken into account for the purposes of public interest expropriation, and then the test is applied.
Yeah.
Why is it so? Why would it be so difficult for the administrator to understand?
So we just submit that with this provision, which is about the local government. So 25.3 main point is that it refers you to circumstances. And it's open-ended, so it's about the use of the land, who it's owned by, things like that.
Factors and circumstances.
Yes.
Why you think to change it? Why do you want to change those factors?
I
and
don't want to change
circumstances?
anything.
Yes.
What has happened in the legislation, the
Yes.
legislation has changed something.
Yes.
It has drawn our attention not to circumstances, but to a specific fact, and said this fact is relevant.
Yes.
And what we're saying is that I understand it may be relevant, and it's going like, but why is it relevant?
Language is
That's
important.
the point, Judge.
Language is important.
Excuse me.
Language is important.
The language is important.
You
Absolutely.
can't keep on skipping may, as if it's not there.
With respect, the point is no higher than this, and I'll leave it at this. It's no good saying you may consider it, and then opaque. Why? And that's the point. And if I'm wrong on that, then but that's the point. It's like, it's just but why is this relevant? You told me it's relevant, but why? And that's and we'd say we don't see it. 12.3c is the abandonment provision. Again, we'd look at this provision and would say the provision, and what was pointed out by the EFF, well, abandonment is a concept that's known in our common law. And with respect, that was a very helpful comment from them, because abandonment is a known concept. But the problem with abandonment is that there's two factors, which is the intention to relinquish, and that, as a matter of fact, you've given up control. That you've given up control completely. And then it's res nullius. So you automatically lose your ownership. You don't need to expropriate. The municipality doesn't need to expropriate abandoned land. If it's abandoned in the sense considered under the common law, there's no need to compensate. There's no need to expropriate in the first place. It is res nullius. It is land in the hands of the states already. So what this section 12.3c is doing, it's creating something new. It's not common law abandonment. It's creating a new kind of abandonment. And the abandonment is measured by whether you have controlled your land in accordance with what you should have been able to do. So it's the consideration is when an owner has abandoned the land by failing to exercise control over it despite being reasonably capable of doing so. And we'd look at so there's no intention to give up. You're saying that they haven't exercised control over the land. Again, we'd say what would that mean? So there may be things that you'd look and go, well, you could reasonably have built a higher fence. You could reasonably have done a whole lot of things, and you haven't. Why would that in itself, would again, be a relevant factor? If it was a category of cases which has arisen several times where a private landowner is failing to secure land and especially making it susceptible to land invasion, well, that's a category of cases we can look and you can go, well, you're creating a problem here. That's something that you can't. And later on, you can't be in the position where you're coming to this court and complaining that the land has been abandoned. If you want to keep the land, but you've failed to secure it, and you've created a problem, and now there's been a land invasion, that may be something that can be considered. But why the mere fact that I haven't controlled my land? Why would that mean that the compensation would go down?
Mr. Watson, why is there an obligation to secure your land against land invaders?
The city of Cape Town has its land anti-invasion force. They go to owners and they tell them to. Well, the problem is that the land is then invaded. Yes. You have the land property owner who comes to this court and now wants an eviction order. Yes. Inevitably, that can't be obtained, and then they go to the city and say, "Well, expropriate the land."
No. Hold on. You come to this court under pass. Just because you've abandoned your land, you are.
Sorry, perhaps I'm being unclear.
You control the property. Those are the requirements of a prior application.
Yes.
Of course, I'm going to say because you abandoned it. Never heard of any case in which it could say
this isn't about. It's a different consideration. We're trying to say we're trying to find a meaning where it could happen. What we're saying is that if you have a landowner who has left their property in a state of what it can be easily accessed and to be occupied, well, we can see that that's a problematic situation that would may be important to the compensation inquiry for expropriation. But the mere fact that somebody hasn't put in a fence of sufficient height, for instance, I mean, why is that relevant to the compensation inquiry? That you haven't controlled your land in a way that the authority thinks you could have, reasonably could have. And with respect, all that we're doing is we're looking at this factual statement. You told me it's relevant. I'm looking at it. Why? Why am I looking at this? Again, that's the point that we have. And we
just understand the thrust of your argument.
Yes.
Earlier on, you were asked whether you accept that one can arrive at nil compensation.
Yes.
When having regard to section 25.
Yes.
And you said yes.
Yes.
Does that mean in your argument that nil compensation is compensation?
We're amongst the applicants. We would be on our own in this one. We accept that null is a number, and that there may be cases based on all relevant facts where you'd have look under the ordinary 25(3) consideration, and we would say that where you would look and you'd go, actually no compensation is due here, and we've looked at the case where that would happen.
But I'm just asking you because we have to interpret statute.
Yes.
Is nil compensation?
We would say the problem is not null. The problem is not the null in the word. Yeah.
Now, in those circumstances, why do the state respondents have to still justify the factors set out in subsection D? Because it seems to me that answer
No, with respect to that
says the provision is not constitutional.
So our
position meets the requirement.
So with respect, our position when we say that that you can get to null as compensation is that because it is relevant in those circumstances. The problem that we have with these provisions is you've told me to look at things and you've told me that they're relevant, but they aren't relevant. We don't understand how anybody would the legislature hasn't just said, oh, well, you can get to null. It's not just a kind of open end, oh, by the way, you can get to null. They pointed the administrator to specific factual situations. And we're saying that there must be something in those specific factual situations which is important to the compensation inquiry. So when we look at these, we're not looking at, yeah, of course you can look at the use of the property. But you've told me to look at this particular use and to put extra attention to the fact that this particular use is something that has a downward effect on the compensation inquiry. So, absolutely, if you look generally at the use of a property, and we can all think of ways that different uses might increase or decrease the property value. But what we say is when you've specifically drawn my attention to one particular type of use, why? And we don't see it, and the legislation doesn't help. And that's what's reflected is all that we're saying. If the interpretation of this court is that ultimately gets to of these provisions is, well, attention has just been drawn to possibilities, they may or may not apply, they may or may not be relevant. Clients could probably live with that. I mean, but the reason they could live with that is because the section just means nothing. It just doesn't matter with respect.
You wouldn't have any problem with the practice under 12B being taken into consideration under section 25B.
If it was if it was relevant.
Well, obviously under relevant circumstances. So if they were relevant under section 25B, and they fall under relevant circumstances as part of the just and equitable consideration, you wouldn't have an issue with it. Your complaint is that section 12B serves no purpose and requires specifically be mentioned. Is that it?
So it goes further than that. So we'd say that a use can be. So we'd like so pointing to the fact that property is unused, or that generally in the section 25.3 inquiry, we would struggle to see why that would be relevant. So I mean, to the so it was something you have to look at. You'd make an assessment that it's unused. The fact that it's unused would be factored into a market value already. So why? What extra importance? Why would you be looking at the fact that it's unused again? I mean, there may be some sort of strange subcategory of cases where it would be a relevant factor that the property is unused, but.
Maybe it's important as to not market value, but personal value to the owner. Because property has value other than market value.
Yes.
You argued that earlier.
Yes.
So market value isn't the only concept
Yeah.
that one needs to take into account.
Accepting that somebody is holding property merely to resell, if you had to ask what is their interest in that property, it would be market value. That's their interest. That's the only reason why they hold it. So in these cases that 12.3a is referring us to, you actually have all that you've done is identified a very particular subset of cases in which market value would be determinative in our submission.
Right, just understanding the sentiment. After the engagement with our system, your client can live with it.
When I say with respect, I mean, we're not disrespectful against whatever judgment does. We would submit it would be wrong to interpret it in that way.
You can live with it.
But I'm saying so we would submit it would be wrong to come to that interpretation because it hollows out these sections. And then only when I say that my client could live with it in that sense, it is only because they are so hollow that they mean nothing. And so we'd go along and go, well, as long as you know, I don't know, they're still there as some sort of vestigial kind of like relic in the act, but it's there you go. It doesn't really matter.
Doesn't matter.
If the interpretation is that, well, look at these things, we're not telling you why to look at them, but look at them anyway, and they may or may not be relevant. Well, then you look. They have to look at everything. So why are you choosing these particular things and saying, look at this particular thing? If there's 50 different things at the side, and I point you to one particular one and say, well, look at that, consider that one. Your first question would be, well, why that one? And if I just looked and said, and I just sort of turned around and walked away, you'd be left bewildered. Why is he drawing my attention to this particular one?
So, but does your argument then require us to evaluate whether or not the policy choice to research those factors in that division is what?
So it's not with respect. It's not a policy question. It is a principled issue. It's on a principled basis whether you've identified a guideline that effectively that assists an administrator in making just and equitable compensation.
This is a statute. This is not just a guideline.
That's
So
been my.
we now being required, according to your argument, as I understand it now, to evaluate whether or not the choice to insert those factors in was correct or not, or was rational or not, or just tell me if I'm wrong.
Let me perhaps I've been slightly too flippant, I think. Our position is this is legislation. Legislation means something. You have referred to specific types of expropriations and specific circumstances that must be important. You said it's relevant, and the fact that you have specifically chosen those and gone to the trouble of including them in a special subsection in the Expropriation Act, it must be something quite important. And that is our problem: is that if you take these provisions as important, that these are irrelevant and important considerations, then we look at them and we go, but they're just not, and it can't be so that they are. Because the fact that land is unused and not currently generating an income, and you're holding it to sell later, would submit that it's not just about the fact that it's a consideration I must take into account. You've drawn my attention to it specifically for a very important reason, and when I ask why, there is no answer. So what is the legislative purpose here? So it's a guideline that creates confusion. Okay, so that's the abandonment case as well. Would submit that that's a particular type of case where it's a abandonment light, it's not common law abandonment. It's a different kind of abandonment, and it's based on the fact that you haven't taken sufficient control. You haven't given up control, you just haven't taken sufficient control measures compared to what you could have. And we don't, with respect, understand why, again, this is something that you've drawn our attention to, or to an administrator's attention to, and why it would be important. The state subsidy question under 12.3d.
Do you accept that it's not the sense of abandonment as contemplated by the EFL?
So, if you have, yeah. So I mean, if it is land that has been abandoned, would that sort of be a common law abandonment?
It's not a common law.
So I mean, if the land was, but there wasn't an intention to abandon, but abandoned in fact. Well, so we'd submit that again. The fact that it's abandoned would look and go. It would be you look at it and go, well, I suppose that shows the person doesn't really care about it. So if I was answering what their interests are, that you'd look and you kind of go, well, that might be something that you would look at. But the section goes a lot further, and the section talks about it's not about even a factual abandonment. It's about the fact that you haven't installed control measures that could reasonably have been expected of you. And then that's where our problem comes in. If it had just been, well, you obviously don't care about this piece of land, you've just walked away, and you maybe don't have any subjective intention to give up ownership, that we could prove under the common law abandonment, but we can see something there, but this goes further. Right, so 12.3d is then the state subsidy question, and again, and the concern here is we understand that there may be a great many cases, and this is one of these provisions where the fact that there has been state investment in the past would be a legitimate concern. It obviously comes from the Constitution, we'd accept that. The problem that we have in the way that it's been presented in the Act here is is particularly a concern with restitution cases. And the problem is that the benefit. So if you have beneficiaries of restitution cases in the past, some of these we're quite talked about that these are very different cases. This is people have been given property as a restitution to as a particular entitlement under the Constitution to correct a past wrong. And if that farm or that piece of property is now not, as has unfortunately happened in many of these cases, that it's not being used, it's not being run very efficiently, and it's on a downward trajectory. If the state expropriates that piece of land from that restitution beneficiary and takes into account the money that the state spent on acquiring that piece of land, we'd submit that would strike incredibly harshly against that restitution beneficiary. So that restitution beneficiary, when they got that piece of land 10 years ago, they could have taken the land or they could have taken money. They chose to take the land. They've had a good go of it. It's not going quite as well as they had hoped. Now the state comes in again and says, well, look here, this seems it's going one way. We're going to pull the plug on this and we're going to expropriate the land from you again, and we're going to take into account what we paid to buy it. That person there's no question of like double compensation or anything. That was compensation the state investment in those circumstances was it was a restitution amount, and this provision again would apply in those circumstances, and and we would submit that would be a deeply problematic article.
So, 25(3)(d), draft 3D. What's the distinction?
25. So no. It's so. Yeah, I mean, that would have to be. We'd have to accept that on this one that there is a mirroring of the Constitution. That the provision. Yeah, it's just that
So
is that you.
the Constitution.
Yeah, but no, but it's again that we would accept that is so, but it's that special attention has been drawn without any attempt to.
It's already there.
Yeah. No. When it was when it was introduced in the Constitution, it was a circumstance that you had to consider. Now you're told that it's a relevant fact to consider, and it has one effect of pushing property values downwards, and that's. I accept the point to take it off. Then there would be 12.4. And 12.4, with respect to, is perhaps the one provision that's important provision with the Labour Tenants Act can be very important, but the way it's drafted does seem to be incredibly vague, and to the point that, and we notice that even the Association for Rural Development in their heads of argument point out that, well, the provision doesn't really do anything other than what was already the case, and that at worst it's redundant. Well, we would think that the fact that it's redundant is problematic in itself, but what we'd submit in this case is that we've seen the Ace versus Mziza case, which is in the SCA, and the SCA considered a compensation claim under 23(1) of the Labour Tenants Act, and it adopted the two-stage du Toit process, and in that case it took market value as starting point, but and the court considered whether the reduced so that the Land Claims Court considered reduced the compensation based on an assessment of other relevant circumstances, including the manner in which the landowner had used the property, and that the fiscus should not be saddled with extravagant claims of financial compensation. And the SCA said, no, that's not something that you could look at in that case. So we'd submit that effectively this provision is drawing again in a determination of compensation, is drawing the attention of an official to a particular fact that the SCA in Ace versus Mziza says is not a consideration. What wasn't a consideration there. So there would have to be something. You can't have an assumption that every case is Daniels versus Scribanti. That there's some sort of terrible injustice happening. It may happen in many cases, but in many other cases,
Labour tenants have been the receiving end historically in this country of the worst kind of abuse.
Yes.
Where literally They work for free, and all they get is a piece of land for their chickens and for subsistence food. So let's not dismiss labor tenants.
No,
They're extremely vulnerable. They've always been vulnerable historically in this country.
just in other words, it gets to what the point of starting with is that we must have this historical account and understanding, but you can't go into an inquiry like this with preconceptions about the facts in that particular case.
353 tells us history.
Yes,
but
so there can't be an assumption going in that because labour tenants as a group have been treated so terribly in the past and still are, that this case necessarily is one in which this person has been treated terribly.
They've been singled out in legislation already, which a court must deal with, or an arbitrator.
Yeah. No, so with respect, this is a provision where there's effectively attention has been drawn to the fact that it may go to zero. We accept that there may be cases where it may go to zero. So if that's but what the only problem we have is that again why that was the case anyway. So what are you doing with the provision? It seems that it must be doing some extra work. So it's surplusage. So that's the Association for Rural Development. They get to the interpretation that, well, it's just surplusage. And perhaps our mistake, if anything, was scratching our heads thinking, well, it must be saying something more. But it really, looking at it, seems to just be, and that's, again, that's a problem in itself. That's a problem for us in itself, that the legislature has included these two provisions, 12.3 and 12.4, that including provisions that are surplusage. It's something which we submit to is an irrational form of legislation, and something that on that basis alone would be something that should be struck down. I really absolutely overstate my argument. The last thing is just on limitations, which we've mentioned. To the point that it gets there, but all that it would say is that if we get to Section 36 inquiry, it's on the basis that there's been unjust and inequitable compensation. If the states wanted to justify it, there would have to be a justification for each of the provisions, each of 12A, B, C, D. They would have to tell us there would have to be a special justification for each of those. It's not, again, good enough to have as the justification that's presented by the Speaker and the Minister to go, well, like land reform is very important. Well, you're looking at, well, we accept that, but you put in a particular provision which has resulted in unjust and inequitable compensation. That's not compensation that's permissible under the Constitution. Why should you be allowed to kind of carry on with that scheme? What are the special factors, societal factors, that mean that besides the fact that there's an identified unlawfulness, that we should, in any event, in a Section 36 inquiry, say, well, it's acceptable in our democratic society. And our point is just that we don't see any of that sort of evidence. There's no attempt at making any sort of justification in any substantive manner, other than relatively broad statements about people want to make rules. That's fine, but it's not good enough for a Section 36 inquiry, and that's what we would. Right. So as far as the orders go, with us, we'd submit that 12.2e, 12.3 and 12.4 would be struck down. The full relief is set out in our notice of motion, including the usual referrals to the constitutional courts, and we'd also submit that we'd be entitled to the costs of counsel. We'd note just a special issue that the EFF have asked for costs against my clients if clients are unsuccessful, and I think it would be only fair to then reciprocate with the same. If my client is successful, then we would ask that the costs be borne by the state respondents and the EFF jointly and severally. Yes. The EFF have opposed the application, and they have asked for costs against my client on the basis that costs between that my client couldn't. If my client loses, it can't raise. I Sorry, excuse me, complete. They can't. My client can't raise BioWatch against the EFF. So that's the point that has been raised by the EFF. But it doesn't apply. BioWatch that wouldn't apply between two non-state parties. And if as we say, that if that's what they're saying against us, well then we'll. That can then go both ways. Thank you, judges. I overstayed my welcome. Thank you, Honor. And I'm sorry, I must mention that when I spoke to my wife over lunch, the first thing she said to me, Judge Slinger's told you, slow down, and you didn't listen. So I better apologize to Judge Slinger. Thank you. I apologize for not listening. Thank you very much, Judge.
Wives are big ones.
Terrible taste in men.
Thank you, Mr. Watson. Who is next? Stock.
Yes.
Is there stock?
Yes. If I can just,
Stock.
yeah, Judge Santana, will you just allow me to move in? Excuse me, can you want to pass me? Push this.
Just push this.
You can move the lectern.
You can move this a little bit.
Well, just take your computer. There's even a banana underneath for energy. I suppose it was also his wife that said that. Justices, if I may proceed. Justices, I'm appearing for SPOC, the Society for the Protection of Constitution, and Mr. Slubbert and I are appearing pro bono. We're not seeking any cost against anyone, and we're also not seeking any cost order. We do so as amicus. We take our brief seriously to act in the interest of the court and to assist the court. We do not necessarily align ourselves to any of the arguments presented before us. So we will give our independent, as far as possible, views relating to this case. Now, what Mr. Du Plessis has argued yesterday, and that's one thing that we agree with him, we say that it's a simple case. He said the judgment can be confined to 1 page. We say it should be confined to 4 pages. Now, and we'll tell you why, because there are different topics with respect that the court should consider, and I'm going to allocate the different topics to the different pages. If I then start then with the first question, arise about the interpretation of the Constitution. The Constitution is a product of negotiation between the old and the new democratic order. In the Constitution, there are already some give and take situation. Public purpose is now expanding the previous dispensation, and market value is no longer the be and all. We also say that the Constitution is for the people, which was illustrated in 1996 when it came out, that we saw different walks of people walking around with a little booklet with the Constitution picture on it, reading the Constitution. So it's for them also to understand. It's for the people. Now, on page 1 of your judgment, judges, the first issue that arises is the interpretation of Section 25 of the Constitution. Now, the interpretation of Section 25, and I'm going to open my act there, is a separate consideration, which should be decided separately to any other, to the specific act. So in other words, first, you will have to refer to the interpretation, and how does one go about in interpreting the Constitution? The Constitution tells you how to go about, because Section 39 of the Constitution tells you what you must take into consideration in interpreting Section 25. 25 falls within the Bill of Rights, and Section 39 deals with it and say interpretation of the Bill of Rights. When interpreting the Bill of Rights, a court, tribunal, or forum, A, must promote the values that underlie an open and democratic society based on human dignity, equality, and freedom, must consider international law, and, this is important, may consider foreign law. So that is a discretion. Paragraph 2 or subsection 2, when interpreting any legislation and when developing the common law or customary law, every court, tribunal, or forum must promote the spirit, purport, and objects of the Bill of Rights. So that is the basis where, with respect, you should begin in approaching Section 25. Now, if one reads Section 25.2 and Section 25.3 and Section 25.8, those are the sections which I'm going to focus on. There can be no doubt for any reader whatsoever that the content of those specific sections say the following. Paragraph 2, property may be expropriated only in terms of law of general application, A, for a public purpose or in the public interest. That we know, there's no debate about that. Public interest is expanding the previous dispensation. And B, subject, and it has to be read in context, subject to compensation, the amount of which and the time and manner of payment of which have either been agreed or by those affected or decided or approved by a court. Now, if I read the Constitution, and I say that will also be the same if any man on the street reads this Constitution, there's no doubt in our mind that it is subject to compensation. And compensation, the word, has got a specific meaning. Compensation means to recompense. In other words, it's not, usually it's for a loss that was suffered. You recompense someone, and that is the specific word. Reading it in context, it goes on, and it says, the amount of which. Now, amount in this sense, I submit, means a numerical amount. In other words, the compensation, the amount of which, so that is number one upwards. It's not a zero, or it's a null or a no. Of which at the time and manner of payment, that's the third clue that we've got, payment. What does amount mean? I've said what it means. It's a numerical amount. It's not a scientific amount for this purpose. Payment of, and payment means to pay something to absolve your debt. In other words, to pay something or give something to take away an obligation, of which either have been agreed or expired, decided by the court. So anyone, and if you're confronted with the confrontation of the interpretation in terms of Section 39 of the Constitution, it is clear that is what has happened here is when the old order and the new democratic order agreed about the future of South Africa and the future of the Constitution, that they specifically agreed that compensation will be payable in the event of expropriation. That is cast in stone. We cannot get away from it. Now, this 25.3, I've heard there were some arguments about that as well. 25.3 deals with a mechanism in calculating the compensation. In other words, the amount of the compensation and the time and manner of payment, once again the word payment, strong, must be just and equitable. So the amount must be of compensation and time and manner of payment, reflecting an equitable balance between the public interest, and then it goes on. Paragraphs A to E of section 25.3 deals with the way of calculating compensation. It does not give the opportunity to say nil or zero compensation. If one say nil compensation, it is tantamount to saying no compensation or zero compensation. If you say that, it's not compensation. It will be a contradiction. But one cannot look at paragraphs 25.3 A to E and try to say that makes it possible for dual compensation. That's not what it does. They say the compensation in terms of section 25.2 must be calculated in this manner by taking those factors. It is actually an abandonment of the previous dispensation where market value was required. Now you can look at all these factors and technically you can come to R1 because it remains an amount, it remains a compensation, it remains something that you can pay. So that is, but we're not dealing with respect in this case, and it must not be conflated. This case is not today about the calculating of compensation. This case is about the principle whether zero or no compensation can be inserted in a law of general application. So if you take the first page of your judgment and you deal with this with the greatest respect, you cannot come to another conclusion that the Act itself, on a proper interpretation, does not allow zero compensation. Now, there are other factors in 25 which I haven't heard in court until now, which is very important, or not elaborately, if it was mentioned in passing. Paragraph 25.5, the state must take reasonable legislative and other measures within the available resources to foster conditions which enable citizens to gain access to land on an equitable basis. We don't have a problem. Spock doesn't have a problem with any land reform. And we don't have a problem with 25 because it says reasonable legislative measures must be taken. But those measures doesn't break down, if one reads it in context, the specific obligations to pay compensation payable and amount as per 25.2 and 3. Then a person or community whose tenure of land is legally insecure as a result of past racially discriminatory law, either to tenure which is legally secure or to be comparable redress, is entitled to the extent provided. That we also don't have a problem. But then it goes to paragraph 7. It also, that must be the source of the Land Restitution Act. It refers to 1913, and we heard all about that. We don't have a problem with that. But it still doesn't change the effect of section 25.2 and 3, that compensation needs to be paid. But now we're getting to the interesting one. That is the only one that I think is of significance and importance for this court to consider. It specifically says the following, and I'm going to read it. No provision of this section may impede the state from taking legislative and other measures to achieve land, water and related reform in order to redress the results of past racially discrimination, provided that any departure from the provisions of this section is in accordance with provisions of section 36.1. Now, if one reads it, this one opens the door for a departure of section 25.2, where compensation is a requirement. It opens the door, but on condition. And there's a jurisdictional fact that, or a key that opens this door, and that is no provision of the section may impede the state from taking legislative and other measures. So the question is, does null compensation or null, I don't want no compensation is more accurate, does no compensation impede the state from taking legislative and other measures to achieve land? So that's the first jurisdictional question that needs to be asked. Now, this is a factual question. In order to answer this question, one will have to look in all those files behind you, Judge Saldanha, and see whether it has been dealt with. It has not been dealt with. The files consist of arguments between the parties, but very little fact. There are no factual propositions by the state to come and say that this, the judge is impeded by no compensation, which is the issue in this court, to take legislative and other measures to achieve land so and so, whether that plays a role. But even if one skips that point, and we say, no, fine, let's accept for a moment, I say there's no facts to substantiate it. It wasn't dealt with in all the papers that were exchanged. We've got boxes full of it. It's not dealt with. There's no exposition about the financial position of the state, or that the state cannot afford. We're not against land reform, but there's no exposition to say the state cannot afford compensation, even that it's a nominal amount, because it's brought down as a result of Section 25(3). So in order to redress a so-and-so, then it goes. But this is the important part. And this is where I'm going to focus my argument for page 2 of the judgment. We're going to say from the provisions of the section is in accordance with the provisions of Section 36(1). Now, 36(1), we submit, plays a pivotal role in the consideration of this case, because we have now seen that the Bill of Rights says that there are property rights, it's subject to compensation, a payment, an amount, and all that. We've seen that. But no right in the Bill of Rights is cast in stone. For that reason, there's Section 36, which can bring in a limitation to a Bill of Rights, whether it's compared to other rights in terms of the Bill of Rights, or for what other reason. The Section 36 is the test to say whether there should be a limitation or a departure or a deviation of the rights in the Bill of Rights. And I'm taking you there. So we say that on two bases. Section 36 are important. We say Section 36 is important merely because there's a right in the Bill of Rights, and that Section 36 can limit a right in the Bill of Rights. We also say so if one reads it in context, because of the reading of Section 25(8), that Section 36(1) comes into play. In other words, if there's a factual finding that something like the no compensation impedes the legislative or other measures to be taken, etc., if that is the factual finding, still the circle is complete. We have to go to Section 36 to consider that. And, yes. Yes, Margaret.
So according to your argument, we'll have to then read sub 2 and sub 3 as placing an obligation to keep the outcome, whatever the mathematics is, but keep it at plus, at 0 plus something.
I wouldn't put it the way that you're saying it, dear Zera. It always has to be an amount.
It always has to be plus.
Yeah,
Greater than 0.
0, no. Amount, yes. To just put it differently, but I think we're on the same.
Yes, I'm deliberately putting
Yeah.
it this way.
Yeah.
I want you to explain to me why.
Because it. Yeah, thank you.
Why is that not? I want you to explain whether or not that is placing an additional requirement to these requirements, to what is set out here. In other words, where do you get the plus? What is it? What 0 plus?
I'm not getting 0 plus. I'm saying it's only, what I'm saying is, if one reads that, and if one asks anyone on the street to read it, they will say that if you expropriate, the expropriation is subject to compensation.
Yes, sorry, what I'm trying to get from you, in terms of sub 3, one must conduct an exercise, not so you called it the mechanism, the calculation mechanism. And now, let's say the administrator arrives at 0.
Yes.
According to your argument, the administrator must up that somehow. And I want to hear why. Because
Because the Constitution says so.
where?
The Constitution says that in each case of expropriation, and we can't get beyond it, we can't get by this. The Constitution tells you, if you interpret that, it says section 25(2), it has to be read together with 3, subject to compensation. Compensation is compensation for a loss, it's a recompense. In the amount, 0 is not an amount. 0 is nothing. Amount is money to be paid.
So that administrator may not arrive at 0.
He can't arrive at that.
Or they may arrive at 0, but they must up it because of these conditions.
I can't see that he ever is going to arrive at 0, but let's accept for your argument that he's arriving at 0.
It's not my argument.
Or the question, pardon
Make
me.
it make sense for me, because this is quite important.
Yes, it's the crux of the case.
Yes.
Yes, we agree on that. So the point is, this is being said to say compensation, payment, and amount. So interpreting that it means that you cannot give no compensation. If you get to an amount of 0 in your private calculations, you cannot give that. Then you can give 10 rand or 20 rand or whatever. And it goes hand in hand, and I will show that to you, with the Expropriation Act. Because that is also the offer that needs to be made. There's no offer if you offer 0. And there's also the amount, they're also using this. You cannot pay nothing. And we bow to the Constitution whether we like it or not, whether we feel that it's unequitable or not, but that horse has bolted, and we're sitting with it now. And that was bolted at the decision-taking stage when they've accepted this Constitution. But I'm glad that you're asking that question. I don't know how is he going to calculate to get 0, but I'll get to that because I'm going to say that's even impossible. Because there are so many factors in land involved. We're talking about, but I'll get to that. But let's deal with this aspect first. So what you are asked to do is to take the Constitution and take Section 39 and give an interpretation. And if I'm wrong, you decide that amount can be 0, then you decide that. If I'm right, you decide amount and compensation and payment is money to be paid, whatever nominal amount being arrived. We're not going to do the calculations today. It's not being asked of us. We talk about the principles, so we don't have to go in that. But then we go, at the end of the day, what we will have to decide with the greatest respect is to decide whether it can be limited if we apply Section 36, because perhaps one can then decide, okay, fine, we're not, even this is the correct interpretation, whether we can walk away from it and say that, okay, 0 compensation is applicable. But I'm going to argue that if we go through the Section 36 test, that you will never allow that to happen. Because it's 36, that is the next topic. 36 will be a consideration of the new Act, Section 12(3), which is the one, the impugned section. Forget about the categories that the people are talking about. We're talking about the first sentence of Section 12, where it says nil compensation, whether that is in line with the Constitution. So that we will focus on. But if you go then the second stage of this argument and start then with a Section 36 consideration. Let us have a look at 36 before we carry on. 36 says the following.
Mr. Slater, my 10 minutes is uninterrupted.
Oh, I apologize.
I've just been waiting for my 10 minutes.
Judge, if we can give you another 10 minutes, I can finish off.
No. I said I'll give you 10 minutes before we interrupt.
Yeah.
So I've been waiting very patiently.
Yeah. All right. But
Really versatile. Because at 36, you only have to deal with 36 if we've dealt with the first page of your judgment.
correct.
And the first page of the judgment,
Yes.
you've left out a very crucial part in section 35.
25.
25, you took us directly from section 25(2) to compensation, and then you said that compensation must be determined on A to E.
Yes.
Huh?
Yes. I said so.
But there's more to it.
Yes.
There's more to it. Crucially, there's more to it. And that's what section 25(3) tells us. Because it says that the payment must be just and equitable. You've never mentioned those words yet, even though referring us to the back of all of these files, which must reflect an equitable balance between the competing interests. Now, we don't, so before we get to page 2, let's just stay at page 1. Why you left it out?
No, what I'm
Because
saying
that's-
is,
Because that's what everybody else argues,
yeah,
except the applicants.
Judge, I'm not,
Those are the controlling principles. Those are the controlling principles in the computation of compensation.
Yes.
Just and equitable, and it's a balancing exercise. So we don't even get to start looking at A, B, C, D, E until we've been able to understand what is the task at hand. So tell us why have you left this out?
Judge, I've dealt with that, and I'm sticking to what I've dealt with, but I can just explain. What I say is the following. That section must be read in context. We're still at the interpretation of the Constitution. That section tells you the following. We know what compensation means because that was determined in section 25(2), and we've dealt with it. I'm not going to repeat that. We know what payment means, we know what an amount means. Now that payment, the compensation, must now be calculated, but it's done on the basis of a positive amount. In other words, compensation. So if we read it in context, we can't just start to read halfway that specific line. It tells you with the perspective, that's what I say, that those will remain my submissions. It says the amount of the compensation. What compensation? What is compensation? So compensation means a positive amount. There's no such thing as no compensation because that's not compensation. Compensation has a specific meaning in the English language. I heard you earlier tell Mr. Bokstrom about the language, which is important. Now the language is very important because we're working with the Constitution. It says the amount of the compensation and the time and manner of payment. That's physical. We used to say in the insolvency court, pay them with clink and the mint. Payment must be just and equitable. So the amount that has to be paid, but it's going from the premise that there needs to be a payment. That is the premise of this court. So if you want to go and calculate the amount of compensation, the time and manner of payment. Payment is paying an obligation. It's not a zero. That's no payment. I've never seen a payment by zero. Must be just and equitable, reflecting an equitable balance between the public interest. So the calculation must be just and equitable. This is what the section tells you. It doesn't deal with allowing zero compensation or zero, whatever you want to call it. There's no compensation. It doesn't deal with, it deals with a manner of calculation, and that's where the mistake was made in what I've heard in sitting in the court. This section has got nothing to do with calculating nil compensation.
Who made the mistake?
In arguments or whatever, I don't know. But I'm not aligned with them. That was the wrong premise. to go onto this one. So you must, with the greatest respect, take this section. That will be forming part of the judgment. I think we can fit it in page 1. And we can then, you come to the conclusion to read it. But then the test will be, and I'm not closing the door to a possible deviation or limitation. That is a test in terms of section 36. All sections in the Bill of Rights can be deviated from. But first you have to follow and interpret the specific section. Now we're going to 36. Because 36 is a weighing exercise, it's a proportional exercise. So now we're going to see whether the facts before Judge Saldana, which are now contained in those files, whether those facts can tell us what weigh in favor of the state. And we say nothing weighs in favor of the state. So if you go to section 36, Judge.
Says you're actually like a 4-page judgment.
I can,
I'm doing the 1-page judgment. He sees that I put it.
But I'm at 4 pages, but I can put it on a WhatsApp and forward that.
Mr. Duplessis says 1 page, you say 4 pages. Mr. Boston says on a chappie's wrap.
But they are already a printed form on the chappie's wrap, and that makes it difficult. 36. The rights in the Bill of Rights may be limited only in terms of a law of general application to the extent that the limitation is reasonable and justifiable in an open and democratic society. And I'm running the risk of saying that I did not include, but there are also A to E, what factors should be considered. I don't want to read it and waste time for purposes of the limitation clause. Now, if one goes, despite the clear wording of section 25, and also as a result of the content of 25.8, which I don't concede the impediment portion, if one go and take it further and you come and consider the facts of this case to see whether the deviation or the departure or the limitation, whatever we want to call it, is reasonable and justifiable, one should do so. And I'll try to do that as quickly as possible. There are 3 factors that judge with the justices should take into consideration. The first factor is the position of the state. The second factor is the position of the owner. Can I just put it here? And the third one is the society. Before I start with the state, I just want to give a brief background in 2 sentences, perhaps 3. Relating to the background. All property always has a value. If one purchases a property, you purchase it for a value, a purchase price. If it's donated to you, there's a value being attached to it. If there's an inheritance, there's a value being attached to it. There are things like transfer duties, donation tax, estate duties, capital gains tax, and all that, by the way, the state that wants to take it without compensation, if it comes to taxation, they accept market value. Market value is the basis for purposes of taxation. Then also, the municipalities in the Municipal Property Rights Act, Local Government Municipal Property Rights Act, they also go and each and every property from border to border, or from wall to wall is more exact, actually goes and value properties. It's a rateable property in terms of the Act. The owner is liable. Even agricultural properties, since the new dispensation, which was not so in the past, those properties are all part of rateable properties valued. There's a valuation roll coming out. And if you don't object to the valuation roll, that valuation becomes cast in stone and is part of a formula to consider the rates payable. So rates is also a factor. So that is just as a background. Now, Section 36, let us consider whether the state can satisfy the justification of a departure. Now, the only justification which I've seen was in one of the amicus curiae said something to the effect that there might be a slight difference in that nil compensation may fast-track land reform. But that is speculative. There's no substantiation. There are no facts placed before you to say that in fact it will fast-track. We cannot say so, we just can speculate. And who was the party that had to bring the justification and the reasonableness? Was the state. They had to come and tell that to this court. They didn't. Now, there is no evidence that the specific nil compensation will make any material difference as far as land reform is concerned. And understand me, I am for land reform and I accept the history. But we want to know whether the nil compensation is going to make a difference to the extent that we deviate from the clear words of this Constitution. The alleged slight difference.
Sorry, on that. It says that payment, compensation, the payment, the amount, and manner must be just and equitable.
Yes.
To assume that the manner of payment will always be monetary.
Yes.
So manner can just then got a very limited manner of being.
I would say,
A monetary value.
Judge Slingers, thank you for that question. I would say that it says that you can pay that in installments or you can pay it in a certain manner. I think that is what's meant with manner. But it still remains money. You're not going to pay him with golden coins or what are these things that you find on the computer these days. That you're going to pay them with money. State pays with that one. So the alleged slight difference to be weighed against possible nominal amounts. We're talking about that was already a concession in the Constitution. It can be any nominal amount because of it. Why is that going to make a difference? As I've said, there's no evidence that the state's unable to pay compensation. But there's evidence, and that I've seen in AfriForum's papers, and I don't know whether it's really disputed. I didn't see any dispute. That the slow progress was as a result of corruption, administrative dysfunctionality, and administrative incapacity. That we've seen with the Restitution of Land Act. There's also no indication that other less restrictive measures will not work. For example, the Restitution of Land Rights Act, why doesn't it work? Why can't they prop it up and let it work, if that is the problem? So to resort to nil compensation as a solution is the wrong way to go. Now we compare that to the owner. That's the next point in this weighing exercise of reasonable and justifiable. It's a fundamental right that the owner stands to lose. It's a property that was acquired by way of cost, directly or indirectly. You don't get the property out of unless someone donates it to you out of the sky. Their payments having been made. These payments were even made after 1994 by people disadvantaged in the previous regime. So we have that type of situation. The people in Mpumalanga, where Spock actually comes from, they went ahead and bought properties all over the show. They bought properties in the outskirts of towns, they bought buildings. Are they now to stand their properties? And they're actually part of the previous disadvantaged group. And then, to pay no compensation while they're paying taxes, while they're paying rates, all based on the market value, that creates an anomaly. The state wants to take, but they forget how they take the money as far as taxes are concerned. And then why is the difference between the public purpose and the public interest? You've got a neighbor. His property is now being expropriated for public purpose and he gets some money there, and yours is now for public interest. There's an equality problem. Then also the bona fide purchaser. This person has bought bona fide in 1994. We're 30 years down the line since 1994. under the impression that land not to be taken with compensation, hopeful to make a quick buck or money out of this proposition. Everyone has to live, everyone has to earn their living, is trying, or he or she trying their best, and now all of a sudden they stand to lose it because of a new act that comes in. That cannot be justifiable. They're losing their investment capital, expenses, taxes, being left with no replacement asset on their balance sheet. This affects the banks and the creditors. Even if they had a property, there were loans granted to this individual person, all of a sudden the asset is gone. Now you have to say, oh, look at my balance sheet, it's just disappeared in the mist. Why must the individual owner pay the brunt of land reform? Why must the individual person of, I think we're 70 million people or 65, now individuals are singled out to carry the brunt of land reform, but land reform is necessary, but why one person getting nil? So it's creating a situation of abuse. Who are the owners? Who are we talking about? These owners can be trusts, can be companies with shares. It can be consisting of people previously disadvantaged, as I've already pointed out. It creates the possibility of abuse, and it will result in endless litigation that we have never seen before the courts. Everyone will be running to the court. So that is as far as that is concerned. As far as the public, the society is concerned, that's the third tier of considering justifiable and reasonable. This act and legislation will shake off investors and damage the economy. No one will invest. They will shy away from a dispensation without compensation. With no compensation, properties can be taken. It will affect the banking and the security system. It will create uncertainty. Now, that is the argument why we say it is not justifiable and reasonable in an open society that this relaxation of the Constitution occurs. And there's no factual substance to show otherwise. Judges, that takes me to the third page of the judgment. The third page of the judgment, even if no compensation is reasonable and justifiable, and this I present in a different way than what was said by the people before me. I say this is an alternative argument. In other words, if the court finds that no compensation should apply, then we can look at sections 12.3a and 3b, two sections that I've picked. And we've done that in our heads to say that there's a problem with that. Now, the problem is, perhaps it was conveyed to you, but not in the same terminology that I'm going to use. It's fettering the discretion. If one has a look at section 25.3, it says the 12.3 of the Act. Now, firstly, there are two discretions to be taken. The first discretion is 12.1. The amount of compensation, that's in line with the Constitution, must be just and equitable, reflecting an equitable balance between the public interest, the interest and so that it carries on. And then it deals with the factors that was already stated in the Constitution. So the official, the first point that he will have to consider, or she, I'm just saying he for practical purposes, I don't want to prolong this argument, it says that the amount of compensation must be just. So that person will have to apply his or her mind to say the amount of compensation, so of what is just and equitable as it is regarding the amount. As the Act now stands, there's a second point. It may be just and equitable for nil compensation to be paid where land is expropriated in the public interest having regard to. So that's another, so there's twice that a discretion should be followed. It might even be as far as 25.3 a subjective discretion. The problem with which I have, or which we have together with my junior rather, is that A to D fetters the discretion. This official is now confronted with this discretion that has to be exercised, and he says, but it reads, if one reads the section, it says the following. I'm not going to be long with this, it has been debated.
Right. Stated easy to discretion or an objective assessment of the facts?
It's a discretion. It's a discretion that has been to be taken. Administrative, it's not really administrative because the court this act doesn't allow for an administrative procedure. The pacha is not applicable, so it's a discretion. So
The
act doesn't allow for pacha.
Okay.
Because if one has a look at section 19, one will see there that the 19.6,
So what is the administrative?
he administrates without pacha because pacha has been taken out of the act.
Okay.
And there's also section 27 that's got an impact on this pacha argument, but if need be, I'll go there. But I don't know. I don't think it's really the crux of the case, but I'll briefly deal with that as well. The point is the following: having regard to all relevance, the may is being now promoted by the respondents as the be and all. May be just and equitable for nil compensation to be paid where land is expropriated in the public interest, having regard to all relevant circumstances, including, that including word is very prominent, including but not limited to. So these circumstances, including, are predefined circumstances. If one reads it together with the preamble of this act, the preamble of this act, if one pages to the front page, it says what it has to done, and then about the third line from the top, to identify certain instances where the provision of nil compensation may be just and equitable for expropriation in the public interest. So this is the aim that was set in the preamble of the act at the top. Or the introductory portion of the act. So the administrator, his discretion is fettered. Now he sees, and that there are many administrators all along the country, they're not sitting in court and perhaps don't know exactly, they just be confronted with this act, and they say including but not limited, and then those factors are set out. And then they say, but these are one of these circumstances that are included. And then they follow that because they say, Mr. X is ticking the box on paragraph A, and therefore we must take his land without compensation. So it's a total fettering of the discretion, and that is the problem. But if one analyzes these specific points, and we go to A, none of those are actually realistic as far as the facts are concerned. It leads this administrator up the wrong garden path of it, taking that person away from the true facts. So what is happening here is where the land is not being used and the owner's main purpose is not to develop land. Now, say for instance, let me just take an example. There are agricultural land plots, what we call outskirts of towns. Some people buy those agricultural holdings for purposes of holding it because they see that the town may develop in that direction, and then they can sell it as for a profit and they keep it. But they don't use it. There's no water on those plots. Some blue gum trees perhaps there, which we can see, especially there in the northern parts, and but there's no water, no electricity, nothing. It's barren land. No one can farm there because nothing is going on there. So those agricultural holdings are bought for purposes of development. But the person who buys it now is not a developer himself. Because to be a developer is not an easy job. You have to have capital. You have to be able to go through the zoning and the rezoning processes, the township development, all lots of money to be expended. But that person is not going to develop the land because he doesn't have the money. Now, all of a sudden, because he falls into this category of not to develop the land, although he wanted to sell it to a developer, He's now in this category, and he doesn't use it. Now, all that he does is he goes and he builds a shack there for one of his personnel or someone that he knows, and then he says, oh, no, we're using it. So it can be circumvented quite easy. And that's already happening. I don't want to testify. But the point is the following.
You want the oath?
Yes. I'll go on the oath, but it still remain hearsay. The point is the following. That is, and then, as was pointed out, the appreciation of the market value. By implication, that already accepts there's a value, because if there's nothing, how can it appreciate? So that doesn't work out. It's leading the decision maker up the wrong road. Then, as far as C is concerned, where the owner has abandoned the land. If land is abandoned, you can bring an application to court if you're the state. You can declare it bona vacantia. You can take it. It's already law in existence. It doesn't have to be. And then this decision maker must now decide on the subjective mind of the owner of the property, failing to exercise control, for instance. The owner can be incapacitated physically. He can be in a situation with no money. He don't have the means to do it or whatever. There are different scenarios. Now, all of a sudden, this administrator is now going to decide, oh, he can't control it. But there might be reasons. Now it places an onus on the owner to come forward to say, no, because of these specific sections, I've got to rebut. I have to tell that this is my intentions. And then the administrator can say, I don't believe you really, whatever. So this is opening up unfettered discretion and opening up abuse. And the question that we need to ask, why is it there? What purpose does it serve? It serves no purpose.
And that's why it's an objective assessment.
Yeah, but all this...
So we're not interested in the subjective.
All this...
The facts will speak for themselves.
What facts? Must the owner now come and present? Bring his attorney and present facts? Does he have an onus?
If he wants to bring his attorney, he's welcome to do so. But only if to provide facts to show that he still has control over the property.
Yeah. This will just be further litigation. Now the last point, and this is now the last point that I'm going to deal with.
The last page of your judgment.
Yeah, I think it's the third one. I've made the judgment a bit shorter. So if one goes and look at, I just want to point out the problems that we have with the Act. This Act is written for purposes of compensation, is written for purposes of amounts to be paid. And I just want to point out the sections, and I would like to do that to the assistants to the court, and I'm not going to be long. Now, there are about 10 sections which I quickly want to refer to, because that will show that Section 12.3 is an exception on the Act. It's a sort of an afterthought that came here, but it doesn't fit into the content of the Act. And we don't have to interpret the Act. That's not our purpose. We have to interpret the Constitution. But that is page 1. We passed that now. So if one has a look at 5.1c of the Act, I don't know whether you have the Act there before you. Thank you, Judge Saldana. 5.1c says the following. The expropriating authority must consider everyone on this page, must consider all relevant circumstances when deciding whether to expropriate property, and must ascertain C. Facts relevant to calculating an amount of compensation, we all know what compensation means, that accords with Section 12, and formulate an offer of just and equitable compensation. If you come with an offer and say, I'm not paying anything, that's no offer. I'll say, go home. I don't want an offer of compensation. For each person would be affected if the property were expropriated. And then also I can just brush on that. There's also a valuer that needs to be appointed, and a whole process that has to be followed. Section 7.2k Section 7.2, notice of intention to expropriate must include, and I'm going to K, an offer of compensation which the expropriating authority considers just and equitable, and an explanation of how the amount was arrived at with reference to supporting information. If we are right in our submission that amount means money, then the amount must, how the amount was arrived, klink in the mint as they say, was arrived at with reference to supporting. So if I null, how can I offer an amount? It doesn't work out as far as this act is concerned. So as paragraph 7.6a, the expropriation authority may decide to expropriate the property after the compensation, the amount of which and the time and manner of payment of which have been agreed with the owner, etc., etc. So that is, all these sections are written on the premises of compensation, payment and amount in terms of the Constitution. It's actually a good piece of legislation apart from a few sections which causes problems. Now, a notice of expropriation, page section 8G, 83G, it's a notice of expropriation must contain, subject to section 20, the amount of compensation agreed upon or approved or decided by a court. So if the offer comes and they don't agree on it, it has to go to court, but it goes to court in terms of section 19.1. I'll get to that soon. And the notice of paragraph 4A, the date and dates on which the expropriating authority proposes to pay the compensation and any interest payable. How do you pay interest on zero? That can't be. And respect thereof in terms of section 13. D, on the next page, an explanation of how the amount of compensation was arrived at, together with supporting documents. Now, 15.1, I just want to stand still at section 12.5. It's also relevant. The property, section 12.5. If the property is land, the expropriating authority must consider the amount of outstanding municipal property rates, taxes, levies, and charges relating to the property when making the offer or just or equitable consideration. So what the legislature there wants to achieve is the legislature accepts that in terms of the MPRA, the owner is, by way of a statute, liable, is an original power in terms of section 229 of the Constitution, and is liable to pay the rates. So if you pay compensation, it must make provisions for the rates. What is a bit unfair, and I would say contrary to the principles of equality, but is not part of the disputes today, is to pay the person if it's outstanding, but the one that's paid his account, he doesn't get anything of these rates. But be that as it may, that's a fight for another day. But the point is they acknowledge, and where there's such amounts, compensation will cover that. You cannot pay zero, because then it doesn't make sense that the outstanding municipality rates be paid, and rates are calculated on value. Then payment of compensation, this is a bigger one, section 15, 15.1, subject to section 16, 17 and 18, an expropriated owner or expropriated holder of a right is entitled to payment of compensation on the date and in the manner as agreed by the parties or as decided by or approved by the court. Now, even if we interpret this act separately in terms of the Natal Joint Pension Fund and the other principles, UJ cases and all that, one will find that compensation means money. That's what it is. So there's a payment of compensation. Paragraph section 17 of this act, payment of municipal property rates, taxes and other charges out of the compensation money. 17.1, the expropriating authority must pay outstanding municipal rates, taxes, levies, and other charges out of the compensation money. So compensation in that sense talks about money. Then 3, the expropriating authority, but then it goes on, there's a mechanism being created in section 17 for the payment of the rates. But there's also, in terms of 17.3b, there's also a situation that there can be a payment on behalf of. But the mere using of the word behalf of means it remains the liability of the owner. The owner is in law liable for rates. So that is all dealt with in that section. I don't have to deal with it because it's not a point of dispute. The only reason why I'm referring to it is because it indicates the importance of it being paid. What is interesting is section 18, and that gives an answer to lots of questions that were asked. Deposit of compensation money with the master. The expropriating authority must deposit the amount of compensation payable in terms of this act with the master, after which the expropriation authority ceases to be liable. So under circumstances, even if the person cannot be found or is gone or whatever, and they get to an amount, they pay it in with the master as security for that expropriation of the property. If a property expropriated under this act was left in terms of a will or testament to an undetermined beneficiary or beneficiaries, that was the old bona vacantia type of situation. If compensation is payable in terms of the act to a person whose address is not readily ascertainable or who, unless otherwise agreed, fails to supply the prescribed information, then they pay it in with the master. If compensation is payable and the expropriating authority, after reasonable endeavours, is unable to determine to whom it must be paid. So money needs to be paid if one reads the whole act in context. The only point that militates is section 12.3. Now, if we go to section 19, that's also a very interesting one, and that's the second one from last, if you allow me. Section 19 says, mediation and determination by court. If the expropriating authority and a disputing party do not agree on the amount, time and manner of payment of compensation, they may attempt to settle the dispute by mediation, and then it goes on. And that was the one, the 19.2, which is a problem because it should be actually intention to expropriate. I think that's the meaning, which was Mr. Havenga also addressed you on that. But be that as it may, if there is a dispute, if the state comes and says zero, no compensation, the owner cannot come in terms of section 19.1 because it doesn't apply to that scenario. It applies to a scenario if the disputing party do not agree on the amount. Zero is not an amount. Time and manner of payment of compensation. So that leaves that owner without section 19.1 to go to court to assess the amount, because this is written on the basis of compensation to be paid. And that is why I say 12.3 does not fit into the picture. It's not written for that purpose. I must say, in all fairness, section 19.6 has got a wider type of approach to the court. Subsection 2 does not preclude a person from approaching a court on any manner relating to the application of the Act. So you can still go with that, and I need to point that out to you as well. So as far as Section 20 is concerned, it also deals with the urgent expropriation, but it says in 25, if not already done in terms of 7.2k, expropriating authority must make a written offer of compensation to the expropriated owner or expropriated holder of a right of reason possible, and then there must be an offer of money to be made, and payment must be made as soon as reasonable possible. Why do they say payment should be made as reasonable possible if it's zero? It doesn't fit in. So then we have briefly in our heads referred to section 27. I don't want to waste the court's time, but 27 creates for us a problem, but we're not the party to this litigation, but we can just point out that what it says is the following, and it should be taken into consideration in looking at the actions of the administrator. 72 says the failure to take any steps in terms of this act as a prerequisite for any decision or action does not invalidate the decision or action if the failure is not material, does not prejudice any person, and is not procedurally unfair. So this administrator can decide, oh no, my problem, this is not material, it is valid. So it's not for the court to decide it, that is now for the official to decide. That's the problem, and I'm leaving it at that. Under the circumstances, Judge, I'm an amicus curiae. I pointed out these points to you. I'm not going to take up any time. But there's one request that I have. The request is that my junior and I are here pro bono, and we seeking leave. We're not going to reply to anyone, and we're seeking leave that we be excused from further procedures because we've got a compensation problem ourselves. So we cannot be here for zero compensation. Thank you, Judge
Seeking to
Alderman.
abandon us.
We're abandoning you. You've got your remedies, but we're abandoning you. If you're a judge, if you will allow us to excuse ourselves. Thank you. Thank you very much.
Mr. Straden, is it Mr. Miller?
It's Mr. Oppenheimer that's going to be next, and we,
Your colleague,
Mr. Slobbert.
Mr. Stubbard.
Thank you.
Mr. Straden, thank you very much for your assistance to the court. And we understand that you need to leave us. But thank you for being here for the past 2 days. And travel well. And we'll see you sometime.
Thank you, Judge. Appreciate it. Thank
The
you.
northern provinces.
Yes. Thank you.
Oh, sorry, people, it's pumpkin time. So we hit the 4 o'clock pass. So we start with the two of you tomorrow morning, Mr. Oppenheimer, bright and early.
That's the go, please.
Any last minute housekeeping for the day? Who else wants to leave? Mr. Kessler pointing at you. Saying that you shouldn't let leave.
I'm here. It's been a long day. No, I think Mr. Manechi is asking the question as to when Mr. Oppenheimer and Mr. Purwal-Sami are finished,
Yes.
whether he goes, because I don't have a right to talk. See, that's the question. I'm the first respondent in the DA case. I've abided, I filed no heads, and the question is, do I have a right to talk? And they take the view that I don't.
You've already exercised it.
That's my view. So my view, after Mr. Oppenheimer's finished, it'll be Mr. Manechi and I say nothing. That's my view.
Well, you've already said something. You've heard what Ms. Hoffmeyer said yesterday. She said if you have anything to say, you're going to put it on affidavit so that you can respond. Otherwise, whatever you said yesterday it's just not there. So you've got to make a choice. The minister's got to make a choice. About going down in writing.
Well, if my lord, sorry, Judge, I have given Ms. Hoffmeyer a case at lunchtime, which suggests that that's not the case. She says she's going to argue why. I don't know what she's going to argue, but she doesn't accept the proposition that when counsel consent, it's not necessary for there to be an affidavit to jurisdiction anyway. Now, there's a case that says that. Now, I don't want to argue it. Maybe Ms. Pillay or some of the others can argue it. I want to say nothing. But if the court is inclined,
saying nothing, why are you with us?
I have to protect my client. I don't know what anybody might say about my client. Anybody can say anything about my client, but he needs to protect himself.
And then what are you going to do?
I might ask for an opportunity to deal with the criticism that comes towards my client. If nobody says anything against my client, I'm quiet. And I'm hoping I'm quiet. I'm hoping to be quiet. But the question about this question of consent or an affidavit or otherwise, if the court wishes to hear from me, I'm available. And the other thing, my lord, is that in my affidavit.
Ms. Hoffmeyer, are you still going to pursue the demonstration on affidavits?
Yes, absolutely.
Yeah, so Judge, may I ask this question? If that's the case, I haven't heard what her argument is. And the question arises is, I've given her the case that says it's not necessary.
She disagrees with you.
I'd like to know why. And
We need
the
to
question
be
on
satisfied.
the other thing is, in my affidavit, my client's affidavit, he does say he's here to answer any questions the court might ask at some particular point. If they ask no questions, I'd be only too happy. So I'm here. That's why I'm here. As a police.
So many questions have been asked in the papers.
Excuse me?
So many questions have been asked in the papers.
Yes, they've been from the court. If the court have any questions,
No, I'm saying that answers the issue about whether or not you should have filed an affidavit if you wish to.
no, he doesn't wish to. You mean on the question of jurisdiction?
Or whatever he says.
He's made an affidavit.
Whatever he says he can be of assistance.
Yes, so he's been of assistance, yes. And if there are further questions that have arisen, bearing in mind affidavits that have come in after his affidavit or during an argument, written or oral, I'm here to try to assist the court in that case. No more, no less.
Mr. Getz, your client is a Minister of State,
Yes,
member of the Executive,
yes,
directly implicated in the provisions of this legislation.
yes.
So he needs to make the appropriate decisions. So you consult with him and take instructions with regard to how he fulfills that responsibility.
Yeah, my simple submission is he has done so by filing what he filed. That's no more, no less. He's done it. But the one issue is, if the court require any answers from him on the issues, fact or evidence or argument that has arisen, I'm here to do it. That's why I'm here. No more, no less. And if the court don't have questions, he believes he's done his duty as a prisoner.
Will you be able to do that without going on paper?
The court might ask me for legal submission, etc., etc. That's up to the court. The court might require me to file something, then he'll have to file something. That's up to the court. He believes that he's done his duty. If the court feels that there's more that's required, then my client has given me instructions to certainly assist the court in whichever way he can, or whichever way the court requires. No more, no less.
Mr. Getz, ex-Abu Dhabi Cartella, this matter is going to meander all the way up. Should your client not just do the appropriate thing and go on affidavit?
About jurisdiction?
Yes.
No. And he's got a very firm.
Fine, if your client makes that selection, then it will be dealt with all the way up.
And he is ready.
All we're doing is that we are affording you the opportunity to do so. If your client elects not to use the opportunity, that's your client's choice. But he's a member of the executive.
May I just ask a question? If he chooses, and he will certainly hear from me this evening, if he chooses not to go on affidavit for whatever reason, may I have the opportunity to argue why that choice was a reasonable and appropriate choice in the circumstances? Because that's only a fair thing to him if he makes that choice.
Well, we're here. You don't get to argue on your own. If it's raised when Ms. Hoffmeyer argues, then we may decide to call upon you to argue.
Yes.
But you give your choice,
Yeah,
you
I
apply
see.
the appropriate advice, but it's the starting of the court processes. And I can't see what your client's reluctance is to go on affidavit of jurisdiction. It's very simple. He said so to you. What's the difficulty?
Well, I'll put it to you, Mr.
Certainly.
May I just add something before, after he sits down, of course, is that my learned friend asks the court whether it might have questions in relation to the merits of the dispute, which he might answer. If it comes to that, we would like those questions to be addressed to him before we start, because we're simply in the dark about what he's going to say, whether he's going to oppose the state or whether he's going to, we don't know, we've got no notice whatsoever of his position on the merits. So we're asking that if, as he asks the court, if it occurs to the court that there are questions regarding the merits of the dispute that the court would like to hear from Mr. Getz, then that should be asked before the respondents start, before I stand up tomorrow. Because I just don't know what he's going to say about what the respondents say on the case after hearing the applicants. And he has not been able to tell us on paper, because that should have been on notice to the court and the parties by way of heads of argument.
Well, there's the explanatory affidavit in which he says he abides the court's decisions.
He doesn't make any submissions on the merits, but he's asking the court if the court might wish to ask him on the merits, which he has said nothing about in the affidavit or in heads of argument. When we are simply protecting the interests of the respondents, that if we should get to that point where he's invited to answer questions on the merits, then he shouldn't come at the tail end of the respondent's case. He should be asked at the front end, so we can deal with what he has to say, because we don't know what it is that he's going to say.
Well, he's taken no position on the merits, as I understand it.
That's correct.
Yeah, but he's expecting that the court might ask him on the merits, and then he will make submissions to the court on the merits.
Well, we will certainly like to know what the minister's position is on the merits, but it's not in our mouths to force him to ask him to tell us. That's his election to make. All we've pointed out, he's a member of the executive. He's firmly involved in this act and the eventual application of it. And if he doesn't want to express a view on the merits, which I suspect may not be necessarily a legal decision, it might be a political decision, that we have to respect.
Yes. I'm indebted to the court. We just wanted the assurance that when we stand up as respondents tomorrow morning, as first respondent, it's not that at some point in the day he might stand up and say he's got something to say on the merits.
No.
That's all we wanted the assurance for. As a
Judge,
court
I will
basis.
give a guarantee that I will not answer anything on the merits unless I'm asked to do so at whatever point the court decides to ask me. And if the court chooses to do so at a particular point, I'll do my best to answer at that point or at some future point. But there will be certainly no unfairness to any of those who have not yet argued thus far. That's certainly, that would be grossly unfair to them and to the court. So that will certainly not be the case.
In response to what Mr. Manechi has raised, my sense is that your client has taken a political decision.
No, with respect.
And hold on, and he's welcome to do that. But there's also a legal issue that arises in this matter, which any court would have appreciated the assistance of the minister on the legal issues. But it's his choice.
With respect, if there are legal issues that arise, and I know Justice Sling has made the point, there's nothing on affidavit, I'm here on behalf of the Minister to answer any question on the legal issue that arises. Factually, he's not in a position to answer, for whatever reason. That would be unfair to the court and to both the applicants and the respondents. But legally, and that's what, with respect, the cases, Darwood, the very first case, there the court criticized the respective the minister for not being in that position. And he says in his affidavit, I'm here for Darwood reasons. That's what he says. I'm putting counsel before the court, here I am, with a particular legal issue, any legal issue. That the court wishes.
His department
Yes.
is going to be part of the execution of this legislation. All the more reason for the importance of him as the executive authority over that department for having been able to assist us with the legal issues.
I accept that.
Because that's really what we've been debating for the past 2 days, legal issues.
Yes.
If he's taken a political decision not to enter the legal debate, that's his choice. But, sorry?
He makes it clear that he's here to assist the court in whatever way he can. If he made a political decision, then he wouldn't have made that offer.
Yeah.
That's my submission.
Practically?
Excuse me?
What does it mean practically? He's available. What does it mean?
Well, there are other things. Factually, he says the 1975 Act is not workable. He says that. There needs to be a...
No, sorry, I don't want you to explain your case. I'm asking you practically, what does it mean when your client says it's available? Because it doesn't file papers. So what must we do? Are you going to file an affidavit and then we must postpone the proceedings so that everyone else can reply to that?
The only affidavit that I would even suggest that he files is this question of consent to jurisdiction. Nothing more, obviously. Factually, there might be other issues. But
yes, that's what I'm referring to.
On the question of jurisdiction.
No, the last thing you just said, factually, there might be active things.
No, he can't find. No, he can't do that. He's not entitled to do that. No, that would be unfair to the court and to everybody else. I accept that. But legally, you don't need to file an affidavit to make legal contentions on any issue. You don't need to make an affidavit in that respect. And there are cases where...
Mr. Getz, so, assuming after Mr. Oppenheimer addresses tomorrow and before Mr. Manechi asked,
Yes, that's the question.
Mr. Getz, what's your client's legal position? What assistance does your client want to give to this court with regard to the interpretation of this legislation, which is the subject of litigation? What is it?
Can I give you an example of something I might say?
It's a short answer.
A short example. Let's assume the court takes the view that Section 19 is unconstitutional for whatever reason.
Yes.
And the court says to me, well, you heard from Ms. Pillay, you know what the respondents say about the question of just and equitable remedy 172 1B. What does my client say about it? That's what you could ask me legitimately, I think. I'll give you one answer. In the legal answer, this court is bound by what he said in paragraph 2 of Prince 3. It's a legal answer. There's no factual involvement. You might take the view that I'm wrong in that submission.
What is your client's position on the legal issues that arises with regard to interpretation?
Yes.
Has your client formulated a view on that? Has he given you an instruction to
Yes.
argue what are the legal positions he adopts on the issues?
If you want me to tell you when Mr. Oppenheimer is finished tomorrow morning, I'll certainly will.
No, but if you say, if you even begin, then Mr. Manechi says,
Yes.
put it in an affidavit so we can respond to it.
Well,
You see, Mr. Getz, the client can't ride on two horses here.
I accept that.
He can't.
I accept it.
And because he may have taken a political decision not to get involved in the fray for whatever reasons, in this court, he's a member of the executive
I accept
who's
it.
going to be responsible for the implementation of this act. At the very least, this court would have wanted him to assist the court as the executive authority on the legal issues.
I accept
Not
that.
his political predispositions.
I accept
We're not interested in that. And that's what you're going to have to speak to your client about tonight.
May I just, I accept that. I accept unconditionally. The question then arises, to my mind, no, I'm trying to say, the legal issues that arise
Yes.
would come from my pen with his instruction rather than in his name. That's how I would understand if it's a legal issue. If it's a factual issue, obviously I can't speak. But if it's a legal issue, it's for me to speak on his instruction.
It's his department, his officials,
Yes.
like so many other administrative officials, are going to be dealing with this legislation. You've heard the arguments today that were meticulously made about how the officials are going to have to deal with Section 12.3 and the factors involved. They've expressed themselves very clearly. They've said some of the officials are going to say, what does this mean? What's the purpose? All of that. It's his officials who are employed by the state
I accept that.
who are going to be carrying out the day-to-day decisions, or at least make day-to-day decisions.
And him in-
And he throws his hands up in the air in this matter because he has taken a political decision not to enter the fray.
If that's what you're putting to me, Justice,
Yes.
I would judge. I would have a different intake. But I mean, I don't want to
But
waste.
what is his decision otherwise? Because he's meant to assist this court legally.
Yes.
Everybody else has done that.
Yes, but he's. Well, I'm trying to answer the best way I can. I'm not suggesting that what you're putting to me is necessarily unfair. All I'm suggesting, he made an affidavit where he set out his position. If the court rejects that position for whatever reasons, then he must take the criticism that comes with it. But all I ask is, and he says in the practice note, which I filed, I explained his position. I mean, I've heard arguments about various different arguments about the interpretation of Section 12 in different parts of it. I'm going to hear different arguments from different other organs, including, there's going to be a whole range. And the minister, my client says, and he says it in a piece of paper to the court, bearing in mind all of this, his best bet is to listen to all the arguments, hear the arguments and the evidence, and do what he can to assist the court. Now, you might take the view that it's an unreasonable stance. You might take that view, but his view is you might listen to the president tomorrow, you might listen to the speaker. There are two different speakers who have different resolutions to the Section 19 remedy, and he might say, well, I've listened to the argument, this is the one that we think would be the most appropriate.
When is he going to say that?
Well, in the practice note, he says, it was told to him, all the others knew about it, everybody knew, it was told to him in the practice note, can't get away, I filed it, I think 2 days after the court issued the direction.
Mr. Katz, he knows what everybody's position is. He's set up in the events of argument. So he knows what arguments are going to be presented. Why does he need to first hear oral argument before he decides what his position is?
Because it might turn out, with respect, judging is that having heard oral argument, he has no submissions. And he doesn't have submissions other than those things that arise from the court. It's very clear.
But he's got the arguments. The
No.
arguments are set up in events of argument which he has. He's got the papers which the parties have filed. That sets up their position.
I mean, I'm not going to argue more with you than I've done. I mean, I don't know what you'd want me to do between now. I can't make an affidavit on the merits between now and when Mr. Oppenheimer finishes. Obviously, I can't do. And it would be unfair to the others anyway. There cannot be no unfairness to anybody. So just accept that from me. I will not do anything that is unfair to anybody. That would be inappropriate. The only question is, he's here, I'm here. If the court doesn't have questions to ask, then I will have nothing. And not a political decision, that's his decision. And I've advised him, in his affidavit, he put Darwood in there. And I was involved in how that happened, with the question of the minister not being available to the Constitutional Court for the kind of remedy. And we look at Prince 3, the world has changed since Darwood. It's a binding decision on this court. So it's easy to criticize the minister when the offer that I've made, in Prince 3 it says it would be unnecessary and incompetent for this court to make the ancillary orders that were spoken about as long ago as Darwin. Unnecessary and incompetent. So what does the minister, how can the minister come to this court and say, well, Ms. Pillay talks about these 9 different choices. I'm just in the minutes. You see, all I'm trying to explain is what the minister's stance is, bearing in mind, for example, Prince 3. And it might well be unfair to criticize him when the binding authority is what I say it is. The others might say it's different.
Well, you've heard what the courts.
As it is.
Some of our views, I said that your client, as the minister in the executive responsible for this legislation, was required to come and assist the court on the legal issues. The client hasn't done that. You being present doesn't indemnify you.
Excuse me, sir.
You being present to answer questions that we may or may not have doesn't indemnify for that. And they would be entitled to be critical of your client in not having been of assistance to this court. The applicants would like to know what your client's position is. I suspect the amicus or amici would like to know what your client's position is. The client's a minister, has executive responsibility and authority. And he comes to this court and he says, you ask us questions and then I'll decide, or I'm available to answer.
Well, can I say this? I've had clients who, I've been in many cases where a particular litigant has abided. And they've come along and they've tried to make submissions. And the court is very critical of those kinds of those clients, of those litigants.
So clients who do what?
The litigants
Yes.
who abide. And then they come to court and they say, yes, we abide, we filed an explanatory affidavit, but in fact, they are either supporting or not supporting one or other of the other parties. And they're not allowed to, and the court says, you be quiet, because you're abiding. Now, you might criticize the minister's decision to abide. If the court decides that it's inappropriate that he abides, then the court will say so. But once he abides, there are many cases where an abiding party, and it's legend, where parties but tend to abide, but in fact they are stalking horse for another party or whatever. Inappropriate.
Sorry, they're stalking?
Yes, so there's a case, a respondent, for example, abides but files affidavits to, I think Judge, no. There was a case where what happens is, it's it's an ATM case where I was for the applicant, and one of the respondents supported my case with an abiding. And the court said, no, you can't do that. That's the point. All I'm saying is, I'm a respondent, I've abided. If the court feels that in abiding I did anything wrong, then the court must say so. If the court feels that should have gone further, then the court will say so. Those are the submissions. But I don't want to get involved in fighting with the applicants or the respondents. That's my legal content. If there are legal issues that arise, I'm here. You know, what does this section say about that? Then of course I'm here to do it. But factually...
Well, they say we can't ask you that without you having motivated their legal position in writing. In fairness to all of them.
With respect.
In fairness to all of them. Not just Mr. Manechi.
No, I understand.
And the President.
Well,
and all you have to do is to have a consultation with your client and say, I'm consulting with you as the executive authority in this legislation.
No,
make some important decisions.
Well, I can't file an affidavit now tomorrow morning. It's too late.
Well,
it's unfair. It's unfair on others. That would be grossly unfair.
So, sorry, Mr. Mukwena, yes?
Judge, even much more fundamentally, a choice has been made by the minister is to abide. And I think the court must respect that. Any affidavit that's going to be filed at this time is going to cause chaos. We have already prepared on the basis of the papers that have been filed. The minister was aware as to when to file all the court processes. They have made a deliberate choice. And it will be unfair to allow Mr. Katz to make any submissions. I think he must take the invitation as it was posed, who else wants to leave, and then he might have to vacate the court. That's the only thing that we can agree with him on.
Sorry, I know it's late in the day, but another problem is that the state's respondents would have expected the minister to support the position of the state as an implementing agent of the legislation. The fact that he comes into court with a I'm available to assist you on any legal position you might take puts us in an awkward position, because what if he takes a legal position that is inimical to the position taken by the state respondents? And that is that's why I think Mr. Manager's position is very important. If there is a disagreement between us and the minister, there is another process of engagement that is intergovernmental process that the two ministers would have to engage in. And it would be unseemly for the minister to be asked questions of even of legal importance, because this case is entirely legal issue, legal interpretation and raises legal questions. For the minister, for the first time, to express an opinion, a legal opinion, on the contentious issues that have been raised. So I would support both my learned friends that I think Mr. Kess's position not to say anything is the correct one. The position that he is putting across, which is that the court might want to ask him questions, is trying to bring himself into the case through the court's almost complicit.
Well,
in the sense that
I'm not sure he wants to bring himself into the case. I think what the minister wants to do is to be at distance and to say, well, the responsibility is really on the court if the court wants accountability from the minister.
Yes.
So when I asked Mr. Katz, what is the minister's position on the legal issues, he doesn't know. In fairness to you, that's fine. You're not going to ask him the question then. He doesn't know. The minister hasn't considered being of assistance to the court in the legal issues. We can't take it further. And we have to respect the fact that all he's been asked, he's been challenged by Ms. Hoffmeyer with regard to the issue of jurisdiction. That if he wants the court to take his position seriously, then they want to be able to respond to it on affidavit. That's all. And he must have that long consultation with his client with regard to the issues that have been expressed by the court and by his colleagues here today. Because it's put the minister in a very difficult position, unfortunately.
We'll hear about it tomorrow once he's consulted.
But I'll report back to you tomorrow morning. How would you want me to take it further? And I'll be totally in your hands, everyone. I think it's only fair to my client. I'm going to speak to my client. I'll come back whenever you tell me to come back, and I'll tell you whatever my instruction to the extent that I'm directed to do so.
Thank you. Thank you for doing that. We appreciate it. Everybody's you're holding your peace now. You need to leave for the afternoon. So thank you very much, all of you, those who've argued today. Mr. Zenga, Mr. Boston. Sorry we gave you a hard time today, but it's just the way we get to understand these things. And then Mr. Lemmy, there you are. Thank you very much. And then the two council from the north. We need to get back, and thank you for acting pro bono in this matter.
Thank you, Judge.
It's commendable to come all the way from Pretoria to carry those expenses of your client, and then to be of assistance to the court. The court appreciates that. The spirit of
Thank you, Judge.
of your obligations to the court. Travel safely, and we'll see you again sometime in Cape Town. Thank you to everybody else. It's been a long day, and thank you for your patience with the court. And we'll see you all tomorrow morning, 10 o'clock.
You dead set on going? Yeah. I'll cover your room if you're too long.
David, what's
Cheers, nice to meet you.
Thank you very much.